Are we muted on? How are we both gonna be in this? And
Good morning. Are both parties ready?
Yes, Your Honor, the plaintiff is ready to proceed.
Defense is ready, Your Honor.
Before we get into the case in chief, let's handle some pretrial matters. Does anybody have pretrial matters? And let's also do introductions at the same time.
Should we start off with introductions, Your Honor?
Yeah, let's do that first.
Good morning. My name is Jack Ayers, appearing on behalf of the plaintiff, Jordan Gilmore. I'd also like to introduce my co-counsel, Regina Campbell. She'll be handling all of the technology today.
Good morning, Your Honor.
Good morning.
Once the defense has made their appearances, we have a few housekeeping matters and one substantive stipulation.
Okay, so let's handle the defense's introductions and let's go from there.
Good morning, Your Honor. Ryan Nacino, appearing on behalf of the defense, Chimes Department Stores. Today, I'm also joined by counsel.
Good morning, Your Honor. Nicole Furlani for the defendant.
Good morning.
In addition to plaintiff's two substantive matters to take up, I'm sorry, plaintiff said they have one. We have two substantive matters to take up when they're done with theirs.
Okay. Plaintiff, do you want to go through your pretrial?
Yes, Your Honor. First, once an exhibit has been admitted into evidence, may we have permission to publish it to the jury, or would you prefer that we ask each time?
You can publish to the jury without asking.
Second, during my opening statement, I'd ask permission to display three exhibits, exhibits 3, 17, and 19. We have a good faith belief that they'll be admitted during trial. May we use those during our opening statements?
Defense, do you have any response to that?
We don't have an issue with that. We'd also like to use a couple exhibits in our opening statement. Those are 2, 3, and 6. We also have the same good faith basis to believe they'll be admitted.
That'll be permitted.
And finally, I want to alert the court that the parties have met and conferred regarding the various versions of the jury instructions, and the operative set of jury instructions will be the version starting on page 20 of the case packet. As for the one substantive stipulation, we met with opposing counsel before trial and stipulated to the admissibility of a limited amount of evidence relating to Ms. Gilmore's injuries themselves. While this case has been bifurcated, the defense offered a general denial. So part of the case that we have to prove is that Ms. Gilmore was injured. Therefore, we stipulated that we will go no further than saying that her knee was shattered and that it required replacement. There will be nothing about hospital bills or pain to this day.
Okay.
With that, we're ready to proceed.
Excellent. Defense, any pretrial?
Plaintiff took care of it, Your Honor. We're ready for substantive issues.
Okay. Let's go into substantive issues.
And Your Honor, from the defense, the two parties have met and agreed to preclude a couple pieces of evidence. The first is exhibits 8 and 9. They are two photographs of the plaintiff's knee following her knee replacement surgery. Parties have agreed those exhibits won't be introduced.
That was 8 and 9.
Yes, Your Honor.
Okay.
And the second, the parties have agreed that plaintiff will not offer evidence of a subsequent remedial measure taken by Chimes Department Stores of installing a light switch following Ms. Gilmore's fall.
Okay.
That's all from defense, Your Honor. We're ready to get going.
Okay. Any other substantive issues we need to address?
Nothing from the plaintiff, Your Honor.
Excellent. Are both parties ready to proceed?
Yes, Your Honor.
Okay. Ready when you are.
May I proceed?
You may.
They knew it was dangerous. They just didn't care. It's a chilly January afternoon, and Richard Geller is strolling through his new department store. He's excited. It'll open next week, and everything looks perfect. He looks up. Brand new lights. He looks down. Brand new floors. He walks to the back, to the employee exit. He steps outside. It's a different world. He looks up. One light. but no switch to turn it on. He looks down. And there's a staircase with a guardrail. But the steps, they're falling apart. The concrete is crumbling. He imagines his employees on those steps, bringing in deliveries, taking out the garbage, going outside for their breaks. So he decides to make one change. He doesn't fix the light, doesn't fix the concrete. No, he decides to remove that guardrail. Members of the jury, 2 years ago, one of those employees fell on those stairs. Miss Gilmore, will you turn on your camera? This is Jordan Gilmore. You'll learn she grew up right here in Waco, went to school here. For 10 years, she worked for the defendant's store, Chimes department store. She was a cashier. Until one day, she climbed those stairs. Without a light above her, she couldn't see. Without sure footing below her, she lost her balance. Without a guardrail beside her, there was nothing to grab a hold of. She hit the concrete and shattered her knee. Thank you, Miss Gilmore. Today, the evidence will show that Miss Gilmore's injuries were caused by the defendant's carelessness. The evidence will show they knew those stairs were dangerous. They just didn't care. As the plaintiff, we have the burden of proof. We have to prove our case more likely than not. So today, we have to prove more likely than not that the defendant's negligence caused Miss Gilmore's injuries. And we will meet that burden today with 3 simple facts. The defendant knew those stairs were dangerous. The defendant required their employees to use those stairs. Those stairs caused Miss Gilmore's injuries. So let's take those one at a time. The first fact that we will prove to you today is that the defendant knew those stairs were dangerous. You'll see injury reports. One of the defendant's employees had fallen on those stairs before, gotten hurt on those stairs before. You'll see manager reports. We need to fix the lights so our employees can see. We need to fix the steps so our employees don't fall. Professional engineer will describe that staircase to you as dangerous. And you'll see it yourself. Steps without corners, broken pieces of exposed metal piping where that guardrail used to be. Now, no rail at all. Second fact that we'll prove. The defendant required their employees to use those stairs, to bring in deliveries, to take out the trash, for their smoke breaks. You'll learn that the defendant, they told their employees in writing, do not smoke outside the front of the store. We don't want the customers to see you. Go out back. And when you're done, make sure you throw away your cigarette butts in the dumpster at the bottom of those stairs. The evidence will show that on January 23rd, 2019, well, Jordan Gilmore was on those stairs because the defendant told her to be. The third fact that we will prove. Those stairs caused Miss Gilmore's injuries. So Wednesday night, Miss Gilmore and another cashier, they're finishing up a smoke break. The other cashier goes to walk inside, opens the door. Miss Gilmore, she starts up those steps. But she can't see the edge because there's no light. And she knows there's no guardrail on the right for her to hold on to, so she clings to the wall on her left. But as she reaches the top, she has to move away from the wall to get around that door. It's when she loses her footing. The moment she hits the ground, she knows her knee is damaged. When she tells her manager's response, you'll learn, was, yeah. Someone probably should have fixed those stairs a long time ago. Members of the jury, you'll learn that we deposed the defendant's owner. And when we did, she blamed Miss Gilmore. Quote, she should have clung to the wall. She should have opened the door all the way. She should have known better. Members of the jury, you'll learn it wasn't Miss Gilmore who put a door in the middle of a staircase. I want to be clear, because I know it can be easy to second guess. It can be easy to look at something with the benefit of hindsight and think about what could have been better. But the dangers in this case, they don't require hindsight, because the evidence will show they were in plain sight. Every description you hear about those stairs today, every photograph, every injury report, the evidence will show the defendant knew about all of these dangers before Miss Gilmore fell. That's why at the end of this trial, we will ask you to find the defendant liable for Miss Gilmore's injuries, because they knew. They just didn't care. Thank you.
Defense?
Yes, Your Honor. May it please the court. The quicker way wasn't the safer way. It's a frigid night in January. A tired employee as she's finishing her smoke break. As she brings it to her lips, her fingers are quivering. Her cheeks are red. The wind is whipping against her face. She's shivering. So she takes one last drag, throws it away, and turns to walk back inside. But separating her from the warm interior of that department store is 5 steps up to a loading dock. And there's a door that's open slightly. open in a way that it's blocking the path up those steps. It's blocking almost the entirety of the steps landing. The employee, she doesn't reach up and pull that door open so she can walk up the steps easily. She doesn't do that normal thing. Instead, she does the quicker thing. She takes her right foot, puts it on the top of that landing, on that tiny piece of concrete that the door isn't blocking. She swings her left leg around the steps, tries and sneak her way past that door and back inside the store. Members of the jury, what you're going to learn today is that that quicker way, it wasn't the safer way. Because the plaintiff, Ms. Gilmore, she didn't sneak around that door and get back inside. She slipped, fell backwards and onto the concrete. Today, the evidence is going to show that in the 10 years Ms. Gilmore had worked at Chimes, she had walked up and down those steps literally thousands of times. Never once slipped, never once stumbled, never once fell. The evidence is going to show that the difference this time was that she was rushing. She was trying to do things the quicker way, not the safer way. Now, today, the plaintiff, she's going to argue that she's not at fault for her fall. Instead, she's going to blame Chimes Department Store, her employer. It was their loading dock that she fell off. Today, you'll learn that Chimes, they're a Waco institution, a family business, stretching back generations. Ms. Geller, can you turn your camera on for us? This is Reese Geller. A couple generations ago, her grandma and grandpa opened up a store that they called Chimes. Today, Ms. Geller, she's followed in the footsteps of her parents and of her grandparents. She's the owner of Chimes. Thank you, Reese. You can turn your camera off. Now, today, it's the plaintiff's burden to prove more likely than not that it was Chimes who acted negligently. And it's the plaintiff's burden to prove that there was an unreasonably dangerous condition on the property, that they should have known about it, and that Chimes failed to act like a reasonable company to fix it. Today, the plaintiff's not going to be able to meet that burden because the evidence is going to show Chimes, they were safe. But there's going to be a second reason that we're going to ask you to find for the defense. That's because we've taken on an affirmative defense. We've taken on a defense to prove, and we have the burden to do this, that it was Ms. Gilmore. It was her carelessness that caused her to fall off those steps. And in order to meet our burden, we're going to prove two facts. That Chimes was safe, and that Ms. Gilmore, she wasn't. Let's take those one at a time. Fact one, Chimes was safe. Today, you're gonna get to see that loading dock that Ms. Gilmore fell off. And you're gonna learn that this loading dock, it's just a little over 2 feet in the air. And I want to say that one more time. The plaintiff's burden today is to prove that this loading dock was unreasonably dangerous, an unreasonably dangerous condition. Now, in their opening statement just now, plaintiff counsel talked about how, well, Chimes, they knew. They knew this was dangerous way back in 2005. But what you're going to learn today is that since 2005, in those 15 years, with employees walking up and down those stairs hundreds of thousands of times? In those 15 years, only one person ever so much as slipped on those steps. Plaintiffs talked about how they're going to prove that defense, they knew that those steps were dangerous. You're going to hear that just before Ms. Gilmore's accident, in 2018, an inspector from OSHA with a decade of experience went out to the property and inspected it thoroughly. Didn't issue a citation. Didn't tell anyone from Chimes that there was a dangerous condition on those steps. Didn't say to anyone from Chimes, you guys should probably fix this. Brings to that second fact that we're going to prove. Plaintiff, she wasn't safe. This is what the steps behind Chimes department store look like normally. You can see the door. It's wide open. Plenty of space to take a step onto that landing. No cause for concern. But you're going to see what these steps look like on the night Miss Gilmore tried to walk up them. You'll see the door blocking the top landing step. And what you're going to learn is that Miss Gilmore, she didn't pull this door open. She didn't ask her coworker to pull it open. Instead, she tried to walk up the outside of those steps. Tried to sneak past that door and get back inside the store. A moment ago, plaintiff's counsel told you Miss Gilmore, she wasn't the one who put a door in the middle of a staircase. But the evidence is going to show she's the one who decided to leave it there and walk up the steps like this. Before this trial, we had a chance to depose Miss Gilmore, and we asked her, why didn't you just pull the door open? Why didn't you move it? Why didn't you do anything so you could step on that landing easily and safely? Her answer? It was cold and windy, and I wanted to get back inside. Members of the jury, we're not going to say today that Chimes couldn't have added more lights, couldn't have put a railing up, couldn't have done something to make those steps that little bit safer. But what we are going to say is that Chimes, they didn't think they needed to. Because for over a decade, employees have been walking up and down those steps, no problem. Because for over a decade, employees, they've been doing the obvious thing. Move that door out of the way. At the end of this trial, we're going to ask you to find for the defense. Because the evidence is going to show Chimes was safe and the plaintiff wasn't. And that the plaintiff's quicker way wasn't the safer way. Thank you.
Plaintiff, you can call your first witness.
Plaintiff calls Jordan Gilmore. May I proceed?
You may.
Good morning. Ms. Gilmore, can you see and hear me?
Yes, I can. Sorry. Good morning.
Oh, good morning.
Good morning.
Please introduce yourself to the jury.
My name is Jordan Gilmore. I'm 48 years old and I'm from Waco, Texas.
You said you're from Waco. Where did you go to school?
I went to the local high school here in Waco
Why did you bring this lawsuit?
because I was injured at work and I shattered my knee and it needed to be replaced.
Let's start at the beginning. You said that you were injured at work. Where was work?
It's at Chimes. It's a department store here in Waco.
When did you start working for Chimes department store?
About 10 years ago.
What was your job?
I was a cashier, so checking people in and out.
You said that you were injured while you were working for Chimes department store. Do you remember the date?
It was January 23rd, 2019.
Where exactly were you?
At the back of the building, taking a smoke break.
Let's talk about why you were taking your smoke break behind the building. In your electronic notebook, can you find what's been labeled as Exhibit 1? And let me know when you've got that in front of you.
Yes, I can. I have it in front of me right now.
What is Exhibit 1?
Exhibit 1 is the memorandum that our manager sent to all the employees talking about where we need to go to take our smoke breaks.
When you say your manager, was that a manager at Chimes?
Yes,
Does that appear to be a fair and accurate copy of the memo that you received from the defendant?
yes, it is.
Your Honor, we offer Exhibit 1.
Any objections?
No objection, Your Honor.
Exhibit 1 will be admitted.
Ms. Campbell, can we bring that up? Now it says on Exhibit 1, apparently the last time Reese came by the store, someone was smoking out front. We can't have that. Who is Reese?
Reese is the owner of the Chimes department store.
When the defendant told you that you could only take your smoke breaks behind the store, did you follow that rule?
Yes, I did.
So let's talk about that area behind the store. In your electronic notebook, can you find exhibits 3, 17, and 19? And let me know when you've taken a look at all three of those.
Yes, I have, and I've taken a look.
Do you recognize what those photographs are of?
Yes, I do.
What are they photographs of?
They're photos of the back of Chimes department store.
Do exhibits 3, 17, and 19 accurately depict the conditions at the back of Chimes department store near the time when you were injured?
Yes, it does.
Your Honor, we offer exhibits 3, 17, and 19 into evidence.
Any objections?
Without objection.
Exhibits 3, 17, and 19 will be admitted.
Let's start off with exhibit 19. What are we looking at in this photo specifically?
That's the back of the department store where we were told to take our smoke breaks.
And where would you stand during your smoke breaks?
Near the dumpster. At the bottom of the stairs near the dumpster.
Well, you said that you'd stand at the bottom of the stairs. Why didn't you just stand on the platform immediately outside of those doors?
Because the memo told us to stand near the dumpster and pick up cigarette butts and trash while we were out there.
If you were going to follow the defendant's instructions to go and pick up cigarette butts down by that dumpster, well, how many ways were there to get down there?
Only one.
What was that way?
Down the stairs.
When you took those stairs, was there a railing?
There was not.
So when you took those stairs, what could you hold on to?
Nothing.
Let's take a look at the steps themselves. How many steps are there?
There are 5.
And of those 5 steps, how many would you describe as being flat and even all the way across?
Only the bottom 2.
What about those other 3?
The other 3 are eroded, they're cracked, they're crumbling. There's exposed pipe as well. Not even at all.
All those photos that we've shown you, they're taken in broad daylight. Did you ever work at night?
Yes, I did.
When you worked at night, how many lights were there?
There was only one light
Where was that one light?
right above the stairs.
Miss Campbell's going to put an arrow onto that photo. Does that show accurately where that light was?
Yes, it does.
Miss Gilmore, in the 10 years that you worked for the defendant, how often was that light on at night?
Never.
Let's go back to January 23rd, 2019. You said that you fell on the stairs. Were you going up or were you going down?
I was going up the stairs.
What time of day was it?
It was about 7 o'clock at night, so it was pitch black.
How well could you see the stairs as you were going up them?
Not very well. It was, like I said, it was pitch black.
How did you fall?
I'm sorry.
How did you fall?
When I got onto the top stair, I had such a small area to stand on that I lost my footing and fell directly onto the ground.
Were you here during the defense's opening statement?
Yes, I was.
Did you hear them say that you had to step around a door?
Yes, I did.
Why did you step around the door instead of opening it all the way?
Because the way the door swings open, it made such a small area, and my friend was standing there holding the door, and with the wind, with how windy and cold it was, I was afraid that she wouldn't be able to hold on to it.
Let's clarify something. You said your friend was holding the door. Who did your friend work for?
Chimes.
When you fell off those stairs, can you describe how you landed?
The ground was uneven, so I landed unevenly on my right side and then fell to the ground. I immediately felt pain in my right leg, my right knee, and my right hip.
And after you felt that pain, after you fell, did you tell your manager?
Immediately.
When you told your manager that you'd fallen off those stairs, what did they say?
My manager told me, I actually can't remember.
Would looking at your deposition help refresh your recollection of what your manager said?
Yes, it would.
In your electronic notebook, can you find your deposition and turn to, I believe it's page 13, lines 12 through 14.
Yes.
Take a look at what's written there and then let me know when you've read it.
Yes, I have.
Ms. Gilmore, did that refresh your recollection of what exactly your manager said?
Yes, it does.
Can you close out that document?
Yes.
So when you told your manager that you'd fallen off those stairs, what did she say?
She said, yes, yeah, we probably should have fixed that a long time ago. I talked to the owner about it, but we always had other problems to fix first.
Thank you, Ms. Gilmore. Your Honor, I have no further questions at this time.
Cross-examination.
Yes, Your Honor. Good morning, Ms. Gilmore. I want to start by orienting the jury a little bit. Can you open up Exhibit 2 on your computer? Let me know when you're there.
I have it.
That's a photo of the loading dock behind Chimes.
Yes.
Looks a lot like one of the photos we just saw.
Yes.
That fairly inaccurately depicts what that loading dock looked like back in January 2019.
Yes, besides the fact that this is a picture in the daylight.
It's a picture in the daylight, but it looks like what the dock looked like back when about time you fell, right?
Yes,
Defense offers Exhibit 2 into evidence.
Any objections?
No objections, Your Honor.
Exhibit 2 will be admitted.
Ms. Furlani, can we get Exhibit 2 on the screen? Ms. Gilmore, this is the loading dock where you fell.
yes,
The object in the middle here, that's the door.
yes,
When you came out and you took your smoke break, you came out onto the platform,
yes,
and then you walked down the steps,
yes,
and you walk back up the steps.
yes,
There's 5 steps here leading up to that loading dock.
yes.
I want to talk a little bit about just how safe that loading dock might have been. January 23rd, 2019 wasn't the first time you walked out there.
No, it wasn't.
You've been working at Chimes for 10 years.
That's correct.
In those 10 years, you'd say you went out on that loading dock about 20 times a week.
Yes,
20 times a week for 10 years, that's over 10,000 times, right?
I'd suppose so.
You'd been out on that loading dock in the daytime,
Yes,
in the nighttime,
yes.
when it was well lit.
During the daytime, yes,
Right, when it was well lit in the daytime.
yes,
You've been out there when there were no lights at all.
yes,
In the 10 years you worked there, every single time you went out, there was never a railing.
correct.
In those 10 years, those 10,000 times you went out there before January 23rd, never once slipped,
No,
never
No.
once stumbled,
not that I recall.
you never once fell.
No,
Now, you said something on direct examination. I want to make sure I caught it right. You were asked about the lighting back by that loading dock.
yes,
And you said there had never been a light on back there? You couldn't remember?
and there, in the 10 years, no, there's never been a light on.
In the 10,000 times you've gone back to that loading dock, you can't ever remember once where you needed a light.
It was never on.
I want to talk about whether your fall was actually Chimes's fault. And I want to really break it down piece by piece. You said that you and a coworker, you went out back.
Correct,
You opened that back door.
correct.
Ms. Furlani, can we get Exhibit 3 back on the screen? When you were out on those back steps, this is where the door was.
That's right.
You and I can agree, on this top step, the landing, there's not a lot of space.
Correct. I agree.
It's pretty narrow.
Right,
It's not easy to walk up the steps with a door like that.
right.
I want to take a look at what you could have done. Can you open up Exhibit 6 on your computer? Let me know when you're there.
I'm there.
Exhibit 6, that's a different photo of the back steps and the loading dock door.
Yes,
In Exhibit 6, that back door, it's wide open.
that's correct.
Fairly and accurately depicts what that loading dock looked like when the door was wide open.
Yes,
Defense offers Exhibit 6 into evidence.
Any objections?
No objections, Your Honor.
Exhibit 6 will be admitted.
Ms. Furlani, can we get it on screen? Ms. Gilmore, this is what the door looked like when it was wide open.
yes,
You'd agree there's a lot more space here on these steps.
sure.
Now, on direct examination, you were asked a little bit about the state of the concrete on these steps.
Yes, yes, I was.
You'd agree in the middle of these steps, concrete looks pretty good.
From the picture, yes.
Now, you didn't open the door like this on the night of January 23rd.
No, I didn't.
You didn't reach up and pull that door open.
No,
They didn't pull it open so you could walk up these steps a little bit easier.
no, I didn't.
Ms. Gilmore, after you fell, your coworker, she did open the door up like this.
She did.
She opened the door up like this and helped you get back inside.
That's correct.
But when your coworker opened the door up like this and walked up the steps, she didn't have any trouble.
No,
Ms. Gilmore, the reason you didn't pull this door open or ask your coworker to open it wider for you is because you were cold and you were in a hurry, right?
I didn't open the door because my friend was holding it.
Ms. Gilmore, you didn't ask her to open the door wider like this because it was cold and windy and you were wanting to get back inside quickly, right?
It was cold. It was cold and windy, and yes, I was ready to get back inside.
So instead, you tried to go around the door.
Yes,
You put your right foot on the little bit of that landing that wasn't blocked by the door.
that's correct.
When you tried to sneak past the door, you lost your balance.
Correct.
You fell backwards.
Yes,
And that is when you got hurt.
yes, it is.
Thank you, Ms. Gilmore. Pass the witness.
Any redirect?
Yes, Your Honor. Miss Gilmore, when you fell backwards, were you able to grab a hold of anything?
No, I didn't.
When you fell backwards, was there anything behind you to protect you from falling off those stairs?
There was not.
Thank you, Your Honor. No further questions. Assuming no recross, may this witness be excused.
Yes, it may be excused. If you can call your next witness.
Your Honor, we have no further witnesses to call in person. However, we plan to read in portions of the deposition of our expert witness, Kelly Danes. We've provided defense counsel with a highlighted copy of the transcript that identifies the portions that we intend to read.
Okay. Any objections to that, defense?
No, Your Honor, we don't have any objections to the portions I intend to read. And just to let the court know, we do have a couple of portions that we would like to read after under Rule 106. We've also provided those portions to plaintiff's counsel.
Absolutely. Plaintiff, you can proceed when ready.
In presenting this testimony, Your Honor, I'll be reading the questions and Ms. Campbell, my co-counsel, will read the answers. I'll call out the page and line numbers for each line.
Okay.
Starting on page 2, line 12, question. Tell us about your education.
I have a bachelor's of science in mechanical engineering from the University of Wisconsin-Madison.
Moving to line 24, question. I noticed that your CV lists you as a PE. What is that?
It stands for professional engineer.
Moving to page 4, line 14. Over the course of your career, how many incidents have you investigated?
Over 60.
Moving to page 11, line 24. Question, what's next?
One moment, let me scroll down. Next, we move to OSHA 1910.23D1 and 1910.24H and IBC 1009.11.
Why are those significant?
All of these provisions require that stairways or flights of stairs must have guardrails or railings on any exposed side. Here, there was no guardrail on the stairs on the exposed side, which is obviously dangerous.
Thank you. No further questions, Your Honor.
Defense, do you have portions that you also want to read in?
You do, Your Honor. Is it okay if Ms. Furlani appears on screen to read those witness answers?
Yes.
And Your Honor, are we safe to assume that you've instructed a jury on what deposition testimony actually is?
Yes, you can assume that.
Thank you. On page 3, line 22. Based on what you do for a living, is it fair to assume that you regularly testify in lawsuits?
Yes, no question about it. I testify and work as an expert on cases on a regular basis. To be honest, preparing expert opinions in lawsuits like this one, testifying in depositions, and testifying at trials are about 99% of what I do at this point.
That's all from us, Your Honor.
We have no redirect by deposition, Your Honor. So with that, the plaintiff rests.
Okay. Defense, are you ready to call your first witness?
Oh, we do have a motion before we do that, Your Honor, if you'll hear it.
Yes.
Defense moves for a judgment as a matter of law under Rule 50 of the Federal Rules of Civil Procedure. Even viewing the evidence in the light most favorable to the plaintiff, the non-moving party in this case, no reasonable juror could find that the plaintiff has met their burden of proof. And where they fail to meet their burden of proof is on the fact that that loading dock was some kind of unreasonably dangerous condition. We heard about the number of times employees had gone up and down those steps over the last 15 years without a railing, without any lights. The plaintiff herself said she'd done it over 10,000 times. And before January 23rd, had never once slipped. Based on that testimony, based on the evidence they've presented, a rational juror could not find that those steps in that loading dock were unreasonably dangerous. And for that reason, defense's motion should be granted.
Plaintiff, any response?
Yes, Your Honor. The defense's motion should be denied. Viewing the evidence in the light most favorable to the plaintiff, a reasonable jury could find that we've met our burden. In a premises liability case, negligence has 4 elements, but it seems that the only one opposing counsel is focusing on is that there's an unreasonably dangerous condition. We've offered expert testimony describing that staircase as dangerous. We've shown that that light was never on at night. We've shown the stairs themselves missing pieces of concrete with exposed pieces of pipe. And we've shown that there was no railing, despite the fact that our expert told you that those stairs should always have railings. We've met our burden, and we can move this forward to a jury.
Defense, I agree with the plaintiff that motion will be denied.
Can't say I'm surprised, Your Honor.
Are you ready to call your first witness, defense?
We are ready to open our case in chief.
All right, let's start that.
Defense calls Reese Geller. May I proceed?
You may.
Okay. Good morning. Can you say your name for the jury?
Good morning. My name is Reese Geller.
Where do you live?
I live in Waco, Texas.
Are you married?
I am.
Do you have any children?
Yes, we have 3.
What do you do for a living?
So I am the owner of Chimes Department Store.
Where is Chimes located?
We're located on Bosque Boulevard here in Waco, Texas.
Ms. Geller, how does someone become the owner of a department store?
So Chimes has been a family business that has run in our family for generations. It started with my grandparents. They were the ones that founded the store. And so then eventually my dad took over the business. And whenever he felt I was ready, I was able to take over the business.
You might have just answered this, Ms. Geller, but how long has your family owned a business here in Waco?
For generations. My grandparents started it, so it's been here for a while.
I want to turn your attention to this case. Are you familiar with a woman named Jordan Gilmore?
I am.
How do you know her?
She worked for Chimes.
Does she still work for you at Chimes?
She does not.
Today, we've heard some claims from the plaintiff about how your store, it wasn't safe. Can you tell us about some of the things Chimes does to make sure there aren't any dangerous conditions in the store?
Yes, we instruct all of our employees, and we make sure that they know how to be safe while on the job.
Ms. Fulani, can we get Exhibit 2 on the screen? How long has this loading dock been there?
Ever since we moved into the building, so about 2005.
Well, what's the loading dock used for?
It's used as a loading dock. So when we get new products shipped to our store, the truck will back up. So that way we could easily get stuff out of the truck and unload it into the store.
Do employees use this dock for anything else?
Yes, for breaks.
Ms. Furlani's going to highlight the door here for us. Where's that door lead to?
It leads to the inside of the store.
Are employees able to go in and out of the store?
Yes,
How many steps is it up to that landing dock?
it's 5.
I want to give you a chance to respond to some of the specific claims that we've heard from the plaintiff. Plaintiff, they've talked about the state of the concrete on those steps. Why didn't you replace or repair the concrete?
Because of the safe.
Well, did anyone ever tell you that the concrete on those steps violated a law
No,
or a regulation?
no.
Plaintiff has talked about how there wasn't a railing on those steps. When was that? How long had that landing dock not had a railing?
Pretty much as soon as we moved in, so probably around 2005 as well.
How was that railing removed?
Our landlord removed it.
When the landlord removed the railing, did they tell you that a step like this had to have a railing?
They did not.
Anyone ever tell you not having a railing violated a law
No one did.
or a regulation?
Yeah, no one did either.
We've heard a little bit about the lighting back behind your store. When employees were going out to that loading dock, was there a source of light?
Yes.
From where?
From inside the store.
In the 14 or 15 years you've been using that loading dock before Miss Gilmore fell, had anyone ever fallen on those steps?
Yes.
When did that happen?
It happened in 2010.
How many times had a person fallen?
It was just a one-time incident.
So you told us that one time in 15 years, a person fell on that loading dock. Were you cited by OSHA for that one instance?
We were not.
Anyone from OSHA tell you there was a danger on the stairs?
No one told us that.
Anyone from OSHA tell you there was a problem?
No one told us we had a problem.
I want to talk a little about how this accident happened and what else could have been done. Ms. Furlani, can we get exhibits 3 and 6 up side by side? We're having Ms. Furlani highlight an object in each of these photos. What's that object?
That's the door.
How does that door open?
Oh, you pull it open.
So if I'm standing at the bottom of the steps, how do I open that door? Do I push it or do I pull it?
You pull it.
Are you aware of anything on January 23rd, 2019 that would have prevented someone from opening this door completely the way we see it in Exhibit 6?
Objection, lack of foundation.
Response.
Your Honor, I'm not sure what foundation could be missing. We're asking this witness if she's aware of anything. If she's aware or not aware, that's something that's certainly within her personal knowledge.
May I be heard, Your Honor?
You may.
There's no evidence that this witness was there at the store whatsoever on January 23rd, 2019. Whether she was aware of something that could have stopped that door from being opened or closed, there's no foundation that she would even be aware of that sort of thing, that was even something that she could be aware of. And opposing counsel's question seems to assume that because she wasn't aware of something, that therefore there wasn't anything there. But we haven't even heard that she was at the store whatsoever that day.
Your Honor, if I can respond.
You may.
I think plaintiff's concern, it's an issue of weight and the weight the jury should give to that evidence. They're certainly able to cross-examine on this witness that she wasn't there and that she might not know for sure. But the question as phrased, going to her awareness and what she knows as the owner of this company, certainly well within her personal knowledge.
I'm going to overrule that objection. Defense, you may proceed.
I'll ask that question again, Ms. Gilmore. Are you aware of anything that on January 23rd, 2019 would have prevented this door from being open completely?
I'm not aware.
Thank you, Ms. Geller. Pass the witness.
Cross-examination.
Yes, Your Honor. Opposing counsel could just bring down those exhibits. May I proceed?
You may.
Good morning.
Good morning.
Can you see and hear me clearly?
I can.
How are you doing, man?
I'm good. How are you?
I'm doing well. I want to start off by clearing something up. Opposing counsel just asked you whether you were aware of anything that would have stopped that door from being opened completely on January 23rd, 2019, right?
Correct.
When Miss Gilmore fell off those stairs on January 23rd, 2019, you weren't there.
I'm not sure.
Did you see Miss Gilmore fall off those stairs?
No.
Did you watch Miss Gilmore?
No.
Did you have any interaction with Miss Gilmore whatsoever that day?
I'm not sure if I had any interaction with her that day, but I did not at that moment.
So let's talk about what you actually knew, what you were actually aware of before Miss Gilmore got hurt. You knew that there were stairs behind your store, right?
Yes.
You knew your employees were using those stairs, right?
Yes.
Let's take a look at those stairs. There are 5 steps, right?
Correct.
The first 2, they look flat and even.
Yeah.
For the 3rd step, well, the corner of that step doesn't look so flat and even, does it?
Just the corner.
Right. So the corner of that 3rd step, it doesn't look flat and even.
Yeah, that's correct.
On the 4th step, well, the corner of that step, it's missing a piece of concrete.
Yeah, that corner also isn't flat and even.
And the 5th step, well, that's damaged as well.
Yes.
There's a piece of exposed pipe sticking up through the top of that 5th step.
Yes.
You knew employees would be working and walking on those steps in that condition.
Yes.
Let's talk about what you knew about the lighting. You knew that sometimes your employees worked at night, right?
Correct.
Sometimes your store required your employees to work at night.
Correct.
Back in 2019, well, there was just that one light, right?
Yes.
But there was no way for your employees to turn it on.
Well, they had light from the inside of the store.
I'm not asking about light from the inside of the store. I'm asking about the light outside the store. You know that Miss Gilmore fell outside the store, right?
Yes.
The only light outside the store, your employees had no way of turning that on.
Yes.
So you knew your employees would be walking on those steps, which, like you said, were damaged, without a light.
Yes, other than the light from the store.
Let's talk about the railing. The defendant, they moved into this store in 2005, right?
Correct.
But when the defendant moved in, there was a guardrail on those stairs, wasn't there?
There was.
You know the purpose of a guardrail was to stop people from falling, right?
Yes.
It guards them,
Yes.
keeps them safer.
Yes.
You said you removed that railing so that you could turn the platform into a loading dock.
The landlord did, but yes.
Well, you asked the landlord to do that, right?
That's correct. Yes.
The landlord never suggested it to you.
That's correct.
You thought that removing that railing would make it quicker to get deliveries into the store.
Yes.
Quicker, but not safer, right?
I guess so.
But when you remove that railing from that platform, well, you also removed it from the stairs.
Yes.
So you knew that employees would be going up and down those stairs at night without a light, without a railing.
I did.
Let's talk about another thing you knew. You knew that someone had fallen on those stairs before.
Yes.
You knew that it had happened years before under the same conditions.
Yes.
One of your employees had fallen at night without a light on those stairs.
Yes.
On direct examination, over and over again, you called this a loading dock, right?
Yes, it is.
And when opposing counsel asked if there were other things it was used for, you said, oh, well, employees, they take their breaks there as well, right?
They do sometimes.
But that's not just where some employees chose to take some breaks, right?
Are you asking if they chose to take breaks there?
I'm asking if you required that employees take their smoke breaks there.
I did.
I'm asking if your company sent a memo to employees saying if they took their smoke breaks, they should go down those stairs and pick up garbage near the trash can.
Yes.
Your company, you also required your employees to use those stairs when they took out the garbage.
Yes.
On direct examination, well, you talked about the things you knew. But let's talk about what you did about those things. You never added lights.
No.
You never fixed those steps.
We did not.
You never added a guardrail.
No.
Your company's been at store for 14 years. Right?
About.
Well, from 2005 to 2019, before Miss Gilmore was injured.
Okay, yes.
14 years, right?
Yes.
In those 14 years, your company didn't spend a single dollar to make those stairs safer.
No.
No further questions.
Any redirect?
Yes, Your Honor. Ms. Geller, you were just asked about what you knew about the lighting and about the guardrail. Before January 23rd, 2019, had Ms. Gilmore ever come to you and said, we need more lights back there?
She didn't.
Had any employee ever personally come to you and said that?
No.
Before January 23rd, 2019, had Ms. Gilmore come to you and said, we need a railing?
No.
Had any employee personally come to you and said that?
No.
Thank you, Ms. Geller. Pass the witness.
Recross, Your Honor.
Sure.
One moment. Ms. Geller, opposing counsel just asked you if before 2019, any employee had ever come to you and said, we need to fix those lights, right?
Correct.
You said no employee has ever done that.
I did.
In your electronic notebook, can you turn to Exhibit 14?
I'm sorry. It's going to take, exhibit 14. There we go. Okay, I'm there.
You've got it in front of you.
I do.
That's the injury report from the last time someone fell on those stairs, right?
Correct.
That's an injury report you'd seen before Miss Gilmore fell, right?
Yes.
On the very last page of that injury report, there's a section that says for chimes use only, right?
Yes.
That's filled out by the management.
Yes, whoever took the report.
There's a question, the very last question on that report. It says, are there any steps that should be taken by Chimes to help prevent such injuries in the future?
Yes.
And the manager answered, make sure there is adequate lighting on the loading dock.
Correct.
No further questions.
Any other redirect?
Yes, Your Honor. Ms. Geller, after that report in 2010, in the 9 years before Ms. Gilmore fell off that loading dock, did anyone else come to you and say there need to be more lights?
No.
Thank you, Ms. Geller. Pass the witness.
No recross, Your Honor.
Defense? Any other witnesses?
No more witnesses that we're calling live, Your Honor. We do have a witness we would like to call by deposition.
Whenever you're ready.
Yes, Your Honor. May Ms. Ferlani appear and read the answers?
You may.
And we've provided the portions we're going to read to plaintiff's counsel. On page 2, line 5. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Perry Hayden.
Page 2, line 11. What do you do for a living?
I am a compliance, safety, and health officer with the Occupational Safety and Health Administration.
Page 3, line 16. How long have you worked for OSHA?
Since I got out of school. So at this point, that's about 13 years.
Page 5, line 6. All right, Ms. Hayden, how are you involved in this case?
Well, I conducted an inspection at that Chimes department store in Waco in 2018. So I assume that's why I'm here.
Page 5, line 16. Why did you inspect the Chimes department store in Waco back in 2018?
It was just a regularly scheduled inspection. We do that all the time. Just show up and do an inspection.
So were there any complaints that led to this inspection?
Not that I'm aware of. I went out there because it had been a while since we had been there. That's it.
Page 6, line 8. Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
That's all from us, Your Honor.
Plaintiff, do you have any portions you'd like to read in at this point?
Yes, we do, Your Honor. And again, I'll be reading the questions and Ms. Campbell will read the answers. Starting at page 11, line 18. Did you notice a light out there when you were doing your inspection?
I did. You'll notice it in my report.
Did you ask the manager about that light?
I did, like you can see in my report.
And what did the manager say?
The manager told me that they always turn the light on when someone goes out or goes back at night. So that seemed good enough for me.
No further questions.
Any other portions you'd like to read in defense?
Nothing more from that, Your Honor. Defense rests.
Okay. Would you all like a short 5-minute break before we begin closing?
That sounds great, Your Honor.
Let's take 5 and we'll be back at 11:14.
Thank you.
Before we get into close, does anybody need any time checks or anything like that?
We'll take a time check, Your Honor.
Okay, plaintiff, you're at about 23:15, and then defense, you're at about 30 minutes.
Not going to use it, Your Honor, but would appreciate it.
Good to know. Plaintiff, is there any time you want to reserve for rebuttal? Do you need a minute marker or anything?
We'll reserve anything we have remaining.
Cool.
May I proceed?
You may.
One moment, Your Honor. May it please the court. It's January 23rd, 2019. Miss Gilmore, she walks up to her manager and tells her she fell off the stairs and shattered her knee. What does her manager say? Does she express surprise? How could that happen? Does she blame Miss Gilmore, as the defense did today? Oh, well, you needed to close and open that doorbell. Does she try to protect her employer? No, our stairs are safe. No, she does none of that. Instead, she tells the truth. Yeah. Someone probably should have fixed those stairs a long time ago. I told the owners. They never got around to it. Members of the jury, you learned that wasn't the first time that the manager of Chimes department store had told the owner of Chimes department store that changes needed to be made. The owner of Chimes department store just got up on the stand and told you, I never knew. No one ever told me anything about those lights needing to be installed. But when I confronted her, she admitted. She'd been told in an official report by the manager of her store, we need better lighting. But when she was told they need better lighting, when she was told those stairs needed to be fixed, what did the defendant do? Nothing. She knew that staircase was dangerous. She just didn't care. Now, as the plaintiff, we had the burden of proof today. But our burden, it wasn't the criminal burden you hear about on television or in film. We didn't have to prove anything beyond a reasonable doubt. Our burden was what's called a preponderance of the evidence. It means more likely than not. That means that we had to prove today that more likely than not, the defendant's negligence caused Ms. Gilmore's injuries. And we met that burden today with three simple facts. The defendant knew those stairs were dangerous. The defendant required their employees to use those stairs. Those stairs caused Miss Gilmore's injuries. So let's take those one at a time. Fact number one. The defendant knew those stairs were dangerous. They knew they were dangerous, members of the jury, because they'd seen them. You saw them today as well. Uneven, cracked, broken. These stairs would be dangerous even in broad daylight. But the defendant knew, that they knew, that at night, in the pitch black, then they were even more dangerous. They knew those lights, you couldn't turn them on. Good luck. They knew those stairs were dangerous because they knew there was no railing. Remember the way Miss Gilmore described going up those stairs. She said she clung to the wall. The defense tried to pretend that this is reasonable. They said, well, the middle of those stairs, they look okay, right? Let's just ignore the fact that the edges of those stairs, which you can't see in the dark, are falling apart. And most of all, the defendant knew these stairs were dangerous because they knew this had happened before. They knew one of their employees had fallen on those steps late at night in the dark without a guardrail and had been injured. And they changed nothing. Now, the defense today, they talked about an OSHA inspection. They said, well, you were never told that those stairs were dangerous by an OSHA inspector, right? Therefore, members of the jury, stairs are fine. OSHA says so. But we read you testimony, sworn testimony from that OSHA inspector. The defendant lied to that OSHA inspector. The defendant told that OSHA inspector, oh yeah, those lights, we turn those on. Every single time we turn those lights on. The fact that the defendant lied to that OSHA inspector, that tells you two things. Tells you you can't trust the defendant. She told you on the stand, no one ever told me about those lights. That wasn't true. She told the inspector, oh, those lights are fine. That wasn't true. But it tells you something else as well. It tells you they were hiding it. Hiding it because they knew. Knew it was dangerous. Fact number two. When the defendant knew those stairs were dangerous, they still required their employees to use them. Over and over again, they kept calling that area out back, well, that's the loading dock. Can't have a railing on a loading dock. They needed you to believe that it was just a loading dock because, as their expert told you, a loading dock, well, that's when you're allowed not to have a rail. That's the only time you're allowed not to have a rail. But just because the defense wants you to believe it's a loading dock, it doesn't mean they can ignore all of the other things that area was used for. The defendant, again, she tried to hide the ball. She tried to say, oh, well, I think some employees take smoke breaks out there. She didn't think some employees sometimes took breaks out there. She knew employees took breaks out there because that's where she told them to take them. She knew employees took those breaks at the bottom of the stairs because she told them, pick up the trash while you're down there. She knew employees were required to walk down those stairs because that's where they had to take the trash. Imagine if I bought a food truck. I tried to use the same arguments that the defendant used today. I don't have to abide by the health code because this is a truck, not a restaurant. This wasn't just a loading dock. It was a place their employees were required to go every single day in the dark at night without a railing. Because they didn't just take the railing off the platform, off the loading dock. They took it off the stairs too. Fact number 3. Those stairs, that's what caused Miss Gilmore's injuries. You only heard from one eyewitness today. The defendant wasn't there. She didn't see what happened on January 23rd, 2019. But Miss Gilmore, she told you what happened. She told you she finished her cigarette and she started back up those stairs, right up against the wall. She told you that when she got to the top, she had to go around the door. Now, the defense, they made a huge deal of that today. They said all she had to do was pull open the door. But Miss Gilmore, she told you why she didn't pull open the door. The defendant's employee was holding it open. It was windy. She thought that if she pulled on the door, well, it would get away from her friend, from the defendant's employee. So she was forced to move around it. But that's what the defense, they don't want to focus on. They don't want to focus on the fact that when she moved around it, well, that's when she had to step on those crumbling edges of the stairs by that piece of exposed pipe with no guardrail to protect her if she fell. When she lost her footing, she landed hard on the concrete. Her knee was destroyed. I want to show you the verdict form. Question 1 on this verdict form, it asks, was the defendant's negligence the proximate cause of Miss Gilmore's injuries? As the judge will explain, negligence is when a building owner knows that the premises are unreasonably dangerous. They don't do anything to fix it. In other words, when they know that it puts their employees at risk, but they just don't care. The defendant knew those lights were out. They knew those steps were broken. They knew there was no guardrail. For 14 years, they had a chance to change that. They did nothing. So yes, you can mark yes on question 1. Defendant was negligent. Because the second part of proximate cause, well, is the proximate cause part of it. And that has 2 parts. Let's make this clear. We have to show that the defendant's negligence caused Miss Gilmore's injuries. In other words, if the defendant hadn't been negligent, Miss Gilmore wouldn't have been hurt. But if there had been a light, if those steps had been maintained or repaired, if there had been a railing to grab onto, Miss Gilmore never would have been hurt. The second part of that standard is that that's foreseeable. Members of the jury, it's foreseeable that if you force your employees to take stairs late at night without a light, when those stairs are falling apart and there's no guardrail to hold on to, nothing to grab a hold of if you begin to fall, that someone might get hurt. That's why on question 1, you can mark yes. The defendant, they brought an affirmative defense as well. They tried to say, well, you have to blame Miss Gilmore because she didn't move around that door. Members of the jury, they're admitting that the outside part of their staircase was too dangerous to walk on. So for that section of the jury instructions, you can write no. Miss Gilmore, she wasn't negligent. She was doing what her employer told her to do. As we told you in our opening statement, it can be easy with the benefit of hindsight to think about what things could have been done better. But the defendant didn't need hindsight. Nothing the defendant has learned since 2019 came up in trial today, because all of those dangers they knew about beforehand. All of those dangers were in plain sight. And they did nothing about it. When they knew the lights needed to be replaced, they didn't. When they knew the concrete needed to be fixed, they didn't. Instead, they got rid of that guardrail and told their employees to use the stairs anyway. We ask that you find the defendant liable for Miss Gilmore's injuries. because the defendant, they knew. They just didn't care. Thank you.
Defense?
Yes, Your Honor. May it please the court. $10,000. The plaintiff walked up and down those steps 10,000 times in the daylight. At night, when it was well lit, when it was complete darkness, 10,000 times. And not once did she slip, did she stumble, did she fall. Not once until January 23rd, 2019. Members of the jury, the evidence has shown that what was different that night, the plaintiff, she was rushing. She was trying to do the quicker thing instead of the safer thing. And I want to be really clear. We're not saying she's a bad person because of that. We're not saying that she deserves to get hurt. But the facts have shown that her fall, it wasn't Chime's fault. Because the plaintiff, she wasn't being safe. Now, as we told you in opening statement, we had a burden to prove that affirmative defense. But as the judge will explain, if the plaintiff can't meet their burden first, you don't even get to our burden. If the plaintiff couldn't make their case, that's it. We're done. Nothing else to talk about. And as we sat and we listened to the testimony, as we saw the evidence, it became clear. The plaintiff, they can't meet their burden. Brings us to the first of those two reasons I told you you'd have to find for the defense. Chimes was safe. Say the plaintiff had to prove that there was an unreasonably dangerous condition on Chime's property, a condition that would lead to a substantial risk of harm. Say the plaintiff has said that that unreasonably dangerous condition was this loading dock. This loading dock that was no more than 2 feet off the ground. This is their unreasonably dangerous condition. Members of the jury, I'm not the tallest guy in the world, but this wouldn't even come up to my waist. And look, we're not saying that someone can't get hurt on this set of steps. Someone can't get hurt on that loading dock. What we are saying is that something like this, it can't be unreasonably dangerous. When you look at this set of steps, and the person with the biggest fear of heights in the world would look at this and say, that's not a big deal. Plaintiff, they kept talking about how, well, back in 2010, someone slipped on those steps, and that's a big deal. That proves our case, proves those steps were unreasonably dangerous. That was one person, one time. And remember what we heard from the plaintiff. She had walked up and down those steps in the 10 years she worked there over 10,000 times. And that's just one employee. Think about all the other employees walking up and down those steps, they're 10,000 times. All those trips on that loading dock, one person slipped once. That's not proof that those steps were unreasonably dangerous. It's not proof of anything. Brings us to the second element the plaintiff had to prove. They had to prove that Chimes, they should have fixed those steps, that they failed to act with ordinary care that an ordinary store would under similar circumstances. And for this, they talked about how, well, those steps, they had problems with the concrete, with the railing, with the lights. Today, you heard from exactly one witness who doesn't have a dog in this fight. Doesn't have any relation to either of the parties. And that's Perry Hayden, head ocean inspector. And on the concrete and the railing, that ocean inspector went out there just a couple months before Miss Gilmore fell off the steps. That ocean inspector didn't write a citation, didn't say this railing's a problem, that concrete's a problem, nothing like that. In their closing argument, plaintiff's counsel just said something about a food truck denying that they don't have to follow restaurant health codes. But what they ignored, the fact that they're missing, and to keep the plaintiff's metaphor going, in this case, the health inspector went out, looked at the railing and said, lack of railing, and said, that's fine, you don't need one. Looked at the concrete and said, yeah, that's okay too. Plaintiff, they talked about how, well, there need to be more lights. Should have put lights up there. And you can use your common sense on this one. 14 years, people walking up and down those stairs, no lights. One person slipped and fell once. That's not unreasonably dangerous. And an ordinary company, tens of thousands of hundreds of thousands of trips on those stairs, one person once, it's not unreasonable to not put a light up. Plaintiff, they made a big deal. They said, well, a manager for Chimes, they lied to OSHA. And so that means that they're responsible. That means they knew there was a problem. And look, Chimes, they're not proud about that. They're not proud that one of their managers lied. But the question you're deciding today isn't whether back in 2018, if one of the managers from Chimes told a lie. The question is about who's at fault for the plaintiff's fall. The question is, was it unreasonably dangerous for there to not be a light up there? And the evidence has shown those tens of thousands of trips, they prove, yeah. Chimes, they didn't need to put a light there. Plaintiff, they made a big deal about that report from 2010. About how, well, Ms. Geller, she was told there need to be lights up there. They knew they should put lights up. But to hear it the way the plaintiff tells it, you think that the employees were banging on Ms. Geller's door every day saying, Reese, we need a light. Reese, put a light up there. That's not what we heard. The way the plaintiff tells the story, you think the store almost went on strike over lights. But what did the evidence show? And a manager wrote it in a report in 2010. And in the 9 years since, not a peep. Not a single employee who knocked on that door and said, Reese, you got a minute? Not a single manager who at the end of year meetings said, hey, Reese, maybe we should think about this again. The evidence is shown. And the plaintiff, they can't meet their burden to prove that Chimes, they failed to act like an ordinary company. They exercise ordinary care. We're going to show you the verdict form. And because the evidence has shown Chimes, they were safe. For question 1, you can write no next to Chimes. But there's a second separate reason you can find for the defense. Because we took on that affirmative defense. And on this, we have the burden. We have the burden to prove that it was the plaintiff and her own carelessness, her own bad choice that caused her to fall off of those steps. As the judge will explain, we had to prove that the plaintiff failed to act with the ordinary care of an ordinary person in a similar circumstance. So what exactly were the plaintiff's circumstances? This is what she saw. Standing at the bottom of the steps, looking up, she saw this door blocking her path up the steps. What she did is she took her right foot and she put it on the very, very top of this landing spot, the very edge. Tried to squeeze her way around that door and passed. What she didn't do, she didn't pull that door open. She didn't give herself space to step on that landing dock. She didn't give herself the space to walk up those stairs safely. And in this case, we don't have to speculate about what an ordinary person would have done. We know what someone else did. The plaintiff herself, she admitted that her coworker that night, when she helped her get back inside, did pull open that door, did have it open all the way, did make it easy so they could walk up the steps together. Her coworker dragging Ms. Gilmore back inside the store, didn't slip, didn't stumble, didn't fall. And Ms. Gilmore, her choice to walk up the steps with that door in the way, it might have been reasonable if she had a good reason. If the door was stuck, if the door was broken. But that's not what we heard. Instead, when we had a chance to ask Ms. Gilmore why she didn't open that door, why she didn't ask her coworker to push it open for her, she said, well, it was cold and it was windy and we wanted to get back inside quickly. Members of the jury, we're not saying that the plaintiff is a bad person for doing that. We're not saying she deserved to fall off those steps for doing that. But the evidence has shown that the decision that she made was about getting inside quicker and not getting inside safer. So when you look at that verdict form again, on question 1, next to Jordan Gilmore, you can write yes. When someone gets hurt, it's easy to blame the faceless company who just happened to be nearby. It's easy to point the finger at some store. Today, you've met the Gellers, the people who have built a small institution here in Waco that they can be proud of. And I want to be clear about what a verdict for the defense would mean. It wouldn't mean that you endorse every decision they made. It wouldn't mean you agree that they did everything 100% right. But it would mean that you think that the fall on January 23rd, 2019, it wasn't their fault. Because someone was trying to be too quick instead of being safe. And that is what the evidence has shown. That's why we're asking you to find a verdict for the defense. Thank you.
Rebuttal.
Yes, Your Honor. The quicker thing wasn't the safer thing. Removing the guardrails was the quicker way of bringing in merchandise, the quicker way to turn a profit. But as the defendant herself admitted, it wasn't the safer way. It wasn't the safer way when employees were forced to walk up and down those stairs with no light above them, broken concrete below them, and no guardrail beside them. Find them liable. Thank you.
Okay, we're going to give the judges a minute to fill out their ballots. If you guys want to stick around, I think the judges and I will have some comments for you. We'll keep them brief. I know it's been a long day. So if you just give us a few minutes, we'll go from there. So I think we have all the ballots in. We're good to give some feedback. Would y'all judges like to start? And then we can kind of release them and let them go. Anyone of you?
Yeah, sure. I'll start. Okay, so for both of you, I'm going to limit the things that I say that I think you did well, because that's not as helpful as things I think you could improve on. Both of you were good on theme and signposting. You know, 1, 2, 3, that kind of stuff. Set up expectations for the jury. I think that's good. It's really useful. I always look out for that, and y'all both did it. Plaintiff, Mr. Ayers. I was looking for some rules, and I was surprised to find out much later that there was an OSHA statute at play in this case. You know, you want to set the jury's expectations up. If there was a statute that was maybe violated, get that out there. Let them think about that the whole time and bring it up a lot. And then for Mr. Nacino, you know, if Ayers is going to drop the ball and not get that rules of the road statute stuff out right away, then maybe that's why you didn't say anything about it. But it's a big gamble not to get in front of it. You don't want the jury to find out about that from him later. You know, if you don't think it applies, then get out on top of that right away. Let's see. Mr. Nacino, when you're doing cross, you did well on cross. One thing that I could see to improve on, you're asking questions. If they could be easily punctuated by a period rather than a question mark, a really well-prepped witness is going to put up roadblocks when you do that. A well-prepped witness is going to force you to ask them questions. So when you say you went out in the daytime, just add right, you know, you went out in the daytime, right, to that. Otherwise, you're going to waste time. And in front of a real jury, you're going to look like you're an antagonist rather than someone who is trying to help get the truth out. Also, for both you, I saw some objections left out on the field. And, you know, it's personal preference. Sometimes you don't achieve anything. Sometimes you get some points of the jury. There were some evidentiary objections for both of you that I felt like were left out. I won't go into detail because I know we're not trying to spend a lot of time on this. But think about it. You know, you can, I mean, at least 1 or 2 of them that I noted were winnable, especially hearsay. I mean, if there's a good hearsay objection out there, go for it. Make them fight for it. You know, don't let everything in. Let's see. Mr. Nacino, when you lose your motion for directed verdict, you can't say, I can't say I'm surprised, Your Honor. I laughed, but yeah, you can't say that. You really got into a good pace, Mr. Nacino, when you started playing up broke the law. I was like, yeah, they broke the law. That's your rule. I was really happy with that. Let's see, Mr. Ayers. I thought you were done for when we pulled up that, earlier. The note from the manager, really good on cross. And then immediately, Nacino came back with a really nice redirect saying it was 9 years ago. You could have prepped for that. That was a predictable recross on the 9-year-old note. If you had front loaded that with some other, I don't know what the reason is, some other reason why it's still good, I thought it would have taken the wind out of Nacino before he could get around to his redirect. On closing, Mr. Ayers, you did a great job. It was really strong, a little bit risky in your jury argument. Straight up telling the jury that the defendant is a liar is a great way to catch an objection on your jury argument. And Mr. Nacino, nobody hardly ever wins anything except to frustrate the judge and spend time when the jury has to leave the room on objecting on a jury argument. That's one I might have done. I might have gone for that on principle and let the jury see, even if they can't hear the argument for the objection, let them see like everything that guy just said is BS. You know what I mean? So that's more stylistic, but that's all I'm going to say right now because I know we got other judges that want to say stuff too. So thank you guys.
Let's just go around. Stephen, can you go next?
Sure. Hey everyone, can y'all hear me? I'm having some internet stability issues. Are we good? Yeah. Hello? Okay.
Yeah.
You can hear me. Okay, good. All right. So Stephen Lopez did a ton, coached a bit, and judged a whole lot more. Great job. First of all, congratulations to both of you for being invited to this tournament. Everybody's super good, and most of the comments are nitpicky. So we're asked to give just kind of one thing that would help you in the next round, because you're obviously both great competitors. You know, not a lot to say. You could pick everything apart. I think a lot of it is personal preference. Mr. Ayers, in your opening, I thought it was really good. I liked the way you were pointing to the light. I mean, it had a good pace in the beginning and really drew me in. But then I felt like you kept that pace through the whole opening, right? I wanted you to speed up a little towards the end because you were really deliberate in the beginning and kind of painting this really dramatic picture. But then it was that pace through the whole thing. Maybe when you start talking about her injuries and her falling, maybe the pace would have been better for me to pick it up a little bit. But I really like your opening. That's just one little tweak that I thought you could do. Mr. Nacino, you know, great job as well. My one thing for you is in closing, and I thought you did an excellent job in closing. What I didn't like and what kind of had some dissonance for me was when you had the photo up there and then you were like, that thing's only 2 feet tall. It's not even in my, you kind of laughed it off, the dangerousness of it. And I know you have to argue against it being unreasonably dangerous, but kind of the tone and the pointing out, hey, that's not tall. I mean, we know she fell. We know got the plaintiff got hurt. I think you're better served by arguing, sure, somebody could have fallen, but it wasn't unreasonable to have that condition there, right? It just seemed kind of like you were throwing it away there at the end. It's like, come on, bro, that ain't even that tall. And that was kind of, it didn't really ring true with what everybody had been arguing through the whole trial. So I think just tweaking that or just taking out that little two says of you kind of laughing off the height would strengthen your argument of, yeah, you could fall, but it's not unreasonably dangerous. Would have been more sincere to me. I got great job for both of you.
Kathy, do you want to go next?
Sure, I can. I just, can you guys hear me okay? All right. I think you both did an excellent job. I was impressed with both of you. The things I would say, and maybe I missed this, but I think Mr. Nacino, when you were doing your redirect of the defendant, you opened the door on that OSHA report. He had not brought that up in his original cross. Am I right about that?
Yeah, you're right. I think that's to borrow a phrase from Jack. I think that's why I lost the plot.
Yeah, I think so too. So I think that when you're in a real trial, you've got to be really cognizant of that and not just go by your outline. If somebody's not brought up evidence that's harmful for you, don't give them the opportunity to do that. All right. I would also echo what Kurt said, which is when you've got bad evidence, you need to hit it in opening. You've got to try to take care of that in your opening statement so that the jury's not blindsided by it and thinking, I wonder why I didn't hear about that in opening. Were they trying to hide that? Especially when, Mr. Ayers' theme ended up being they were hiding X, Y, and Z, trying to hide X, Y, and Z this whole time. So that's just, that's the fact pattern of this case. That's not something directed at you personally, but just as a learning lesson. Don't open doors that haven't been opened. I thought you guys both did very, very well, though. So thank you for your preparation. I know you had a very limited amount of time to get ready. I thought, Mr. Nacino, your theme of 10,000 times was great. You kind of slipped in closing and said, when you were closing in your closing arguments, you said something about, it doesn't mean because there was one fall doesn't mean that it was unreasonably safe. It doesn't mean anything. Well, yeah, it does. 10,000 times 20 employees and one fall in 14 years means a lot with regard to whether something's unreasonably dangerous or not. So just keep that in mind too. And Mr. Ayers, I thought you did very well on your theme and on your signpost and taking it all the way through the entire trial of the case. So you guys did a good job.
Will, you want to go next?
Yeah, and not to belabor, the comments made have all been well placed. I thought both of you showed really good cadence, good pace. I think that jurors have a tendency to be a little distrusting as lawyers, and good cadence and good pace can bleed into being preachy. Both you guys yielded before you got preachy, and I think that's important. I think that signpost terminology used, I use bumper sticker, it's the same thing. I thought 10,000 times is the bumper sticker of the case was fantastic. Frankly, it's hard to knock that out, Mr. Ayers. You just got to eat it. And dealing with Miss Bailey mentioned, as a lawyer, as a practitioner, I typically take the worst thing in the case that I know is coming at evidence and make it exhibit 1 on my exhibit list because I want to show the other side. 1, I'm not fearful of it. 2, I got to get in front of it. So, it's important to get in front of those things because candor and credibility goes a long ways because, a jury's putting you on trial as much as they're putting the evidence and the facts on trial. And getting their trust at the get-go is, it's the difference in winning and losing, frankly. But, I was impressed with both of you. There is good use of tech on cross-exam, by the way, visualization of how things were presented. The images were good. The highlights, the fluorescence were important. Jurors have gone from, 20 years ago to reading books. Now they get all their information in a tweet. And being able to show them in a matter of seconds what you're trying to say, that could take minutes, is important. So I thought that was important in this particularly narrow window where you've got to convey a message. That's a good way to convey it. So yeah, I think both of you gentlemen are going to be an asset to the bar, and I was very flattered to have the opportunity to watch you both.
So I'll wrap up real quick. First of all, y'all both did great. Good luck to y'all, both of y'all going forward. Y'all were very conversational, very good, very engaging. It was easy to watch. So Jack, I think it's already been hit on in opening. You're very dynamic, but in opening, I didn't really see that. You're very even keeled, very even paced. And it's okay if you don't want to go raise your voice or get real quiet, but you can also speed up your pace or you can slow down your pace to accomplish the same thing. Just keep that in mind going forward. Ryan, with yours, be careful what exhibits have already been entered. I think you offered exhibit 2 when it was already in evidence.
It wasn't. It's a photo that's almost identical. That's exhibit 9.
Oh, okay.
Yeah.
Well, same point. Just be careful. Sometimes a judge doesn't catch that. So I would keep that in mind. But other than that, y'all did great. Good luck.
Thank you, everyone, for the time. Really appreciate it.
Thank you, everyone. Good luck, Ryan.
You too, Jack.
Your name. The only reason I say it is because it's like a verbal reminder for me.
All right, I think everybody gets on. Please open your cameras so that we can know everybody who's here. Good afternoon, everybody.
Afternoon. Yeah, that's good.
All right. 1, 2, 3, 4. Okay. Looks like we have all the scoring judges present. Competitors, do we have everybody present from your teams that need to be here?
Yes, Your Honor.
Counsel for the plaintiff is here, Your Honor. Yes.
Okay, great. Does anybody see anybody not here that should be? All right, hearing nothing. I will go ahead and call the case. The 170th Judicial District Court of McLennan County, Texas is now in session. Cause number TG-CV-001-21, Jordan Gilmore versus Chimes Department Stores Incorporated. Just as a matter of housekeeping from the court, I have put my cell phone number in the chat. So if at any point either a judge or competitor or a witness loses connection or disconnects for some reason, please give me a call or shoot me a text message so that we can stop the round and get everything worked out. At this point, before we get into pre-trial, I'll have our scoring judges go ahead and turn off your camera so that the competitors are the only ones on the screen. Remind everybody that this is being live streamed via YouTube. All right. We have appearances from the plaintiff.
Yes, Your Honor. Good afternoon. My name is Ryan Nacino, appearing on behalf of the plaintiff, Jordan Gilmore. And today I'm joined by counsel.
Good afternoon, Your Honor. Nicole Furlani for the plaintiff.
Okay, thank you. I'll have appearances from the defense.
Good afternoon, Your Honor. My name is John Banks, here representing the defendant, Chimes Department Store, along with my co-counsel, Mr. Riley Davis. We have a few housekeeping matters as well as a motion in limine in 2 parts when the court is ready.
Okay. Let's take up housekeeping matters first. I'll start with the plaintiff. If there are any housekeeping matters from your perspective, sir.
Yes, Your Honor. Just 1 or 2. Do we have the court's permission to display any exhibits after they're admitted into evidence? Would you like us to ask you for permission each time?
As long as they have been admitted into evidence, you may use them at your pleasure without asking permission.
Understood, Your Honor. And before trial, myself and defense counsel were able to meet. We've agreed that certain exhibits will be pre-admitted. I have that list ready whenever Your Honor's ready.
Okay. My clean list. Okay, what exhibits have been agreed pre-admitted?
Those are exhibits 2, 3, 6, 7, 16 through 21, and then exhibit 32.
Okay, so that was 2, 3, 6, 16 to 21, and 32. Is that correct?
Yes, and I think you missed 7.
7. Okay, 7. And is that accurate, Mr. Banks?
Yes, Your Honor.
Okay. Exhibits 2, 3, 6, 7, 16 to 21, and 32 are admitted.
And Your Honor, we're okay to put up a couple of those during our opening statement?
Yes, you may.
Understood. That's all we have from the plaintiff, Your Honor. I believe defense has a couple issues they want to take up.
Okay, Mr. Banks, are there any housekeeping matters, first of all, from the defense?
Yes, Your Honor. May we assume that all witnesses have been pre-sworn?
Yes.
Just to put the court on notice, both live witnesses are parties in today's case. So the rule does not apply and no witnesses may be sequestered under the rule.
Very well.
When handling evidentiary arguments, may we assume we are outside the presence of the jury?
You may do so if you ask.
Yes, Your Honor. And once you have made a ruling on a constructive sidebar, may we assume we are back inside the presence of the jury?
Yes.
In the case a witness is having difficulty accessing their electronic case file, may we share our screen constructively outside the presence of the jury for the purposes of laying foundation for that piece of evidence?
Yes, as long as you make it clear that that's what you're doing.
Yes, Your Honor. to put the court on notice, this case has been bifurcated and today's trial deals only with liability.
Okay.
And as such, we discussed with opposing counsel pre-trial and have agreed to exhibits 8 and 9, which are pictures of the plaintiff's leg with staples in it as inadmissible in today's trial.
Okay. Is that accurate, Mr. Messino?
That's right, Your Honor. We've agreed that 8 and 9 will not come in.
Very well.
And that is all for defense's housekeeping, Your Honor. We just have a motion limiting in 2 parts.
Okay. Plaintiff, do you have any motions in limine or other pretrial motions?
Nothing substantive, Your Honor.
Okay. Let's hear your motions, Mr. Banks.
Yes, Your Honor. This time, the defense moves to exclude any evidence or testimony regarding a prior instance in 2010. As mentioned during the defense expert's testimony, as well as Exhibit 14 under Rule 403, because it will confuse the issues in today's trial.
Okay. What is this incident? Give me some more information.
Yes, Your Honor. The prior instance was from 2010 with a different employee at the back of this store who went down the stairs and slipped on loose concrete at the bottom of those stairs. Back in 2010, and this incident we are here today about happened in 2019, Your Honor.
Okay. What's your response, Mr. Messino?
Yes, Your Honor. We believe that this prior instance in 2010, both mentioning it in testimony and the exhibit itself, Exhibit 14, that both of them, the probative value is not substantially outweighed by any danger of prejudice or confusing the issues. Defense is right. In this case, we're talking about an instance where our plaintiff, Jordan Gilmore, slipped and fell on steps behind defendant company's store. In 2010, another employee for the company slipped and fell on those same steps. We want to offer that evidence, and it's probative for 2 reasons. One, because it shows and goes toward our burden of proving that there was a dangerous condition on those steps. The way the concrete was loose and would enable someone to slip and fall. And the second reason it's probative is because it goes toward the notice and the knowledge defendant company had about those steps and that dangerous condition. Both of those have significant probative value in this case because they go directly to elements that we have to prove. And that probative value is certainly not substantially outweighed by any confusion or misleading. Well, we're going to be very clear when we talk about these issues. One was in 2010 and one's Ms. Gilmore now. We're going to keep those separated for the jury.
Okay. I'll allow you a brief response, Mr. Banks.
Yes, Your Honor. As it relates to the unfair prejudice, when weighing the unfair prejudice of any piece of evidence, there's a 2-pronged test that the court applies. First, would a limiting instruction be able to cure any unfair prejudice presented by this evidence? In this case, Your Honor, it would not be able to cure any prejudice stemming from this evidence, as the instances are similar, and it would confuse the jury regardless of opposing counsel's attempted efforts to separate those 2 issues. Further, Your Honor, once a limiting instruction is unable to cure that prejudice, we look if there is a better or less prejudicial way to introduce that evidence. And there is testimony, Your Honor, in this case that is less prejudicial that can get the same point across as to notice for the plaintiff's case.
All right. Well, clear this up for me, Mr. Banks. How are these so similar that you think the jury wouldn't be able to differentiate between them, or so dissimilar that they're not relevant?
Your Honor, it's the same set of stairs. There are 2 employees who are both cashiers at the time, same time of year, and the same time of day. Those issues alone are enough for the jury to confuse which issue opposing counsel is mentioning in one instance versus another.
Okay. I'm going to deny your motion to exclude, but I'll grant a motion in limine on it, just so we can see where the evidence is at when that presents itself. So before there's any testimony about any of these issues, let's approach the bench and we'll talk about it at that point.
Your Honor, does that mean you don't want us talking about that prior instance in our opening statement as well?
Yes.
Understood.
Yes, Your Honor.
Was there another part to your motion?
No, Your Honor, there was not.
Okay. Anything else to bring up before the court before we begin opening statements?
Not from the defense, Your Honor.
Not from the plaintiff, Your Honor.
Okay. All right. We will have opening statements now. Mr. Messino, you may proceed when you're ready.
Yes, Your Honor. Their dock, their steps, their fault. It's a Wednesday night in January. Jordan Gilmore, she's at the bottom of a loading dock behind Chimes department store. She takes a look at her watch. 7:05. Breaks over. She takes one last drag of a cigarette, throws it away, and turns to walk back up the steps. And she does it slowly. She takes her left hand, puts it on the wall next to those steps, uses it to guide her every step. Because when she looks down, she can barely see the steps in front of her. It's pitch black. As Miss Gilmore climbs the steps, she goes to put her right foot on the landing. And she can see her coworker holding the door open for her. But what she can't see is that step that she's about to put her right foot on, it has a gaping hole in the concrete. The concrete on that step, it's eroded. That step, it's broken. And when Miss Gilmore puts her foot down, she slips. She loses her balance and she falls backwards off the steps and down onto the concrete. Members of the jury, the evidence is going to show that that loading dock and those steps were controlled, maintained, operated by the defendant, Chimes department store. The evidence is going to show that those steps on that loading dock were worn or eroded. The steps were broken. The concrete on them cracked over years. The evidence is going to show that those steps, they were a dangerous condition. And that dangerous condition caused Miss Gilmore to get hurt. Miss Gilmore, can you turn your camera on for us? This is Jordan Gilmore. She fell off those steps in January 2019, more than 2 years ago. And now 2 years later, she can't work. She can't walk. She can't do any of the things she used to do. Thank you, Jordan. You can turn your camera off. Ms. Gilmore is suing the defendant for her injuries. Today, as the plaintiff, we have the burden of proof. We have to prove more likely than not that it was the defendant's negligence, their failure to act like a reasonable company, that caused Ms. Gilmore to get hurt. And to meet our burden, we're going to prove 3 facts. That there was a dangerous condition, that they didn't fix it. And because they didn't fix it, Ms. Gilmore got hurt. Let's take them one at a time. Fact 1, there was a dangerous condition. This is the defendant's loading dock. And these are the stairs on that loading dock. You're going to see these steps today, and you're going to see the concrete with holes in it. Concrete that's worn away, holes in the bottom and the top step from where they ripped out the railing years ago. You're going to learn these steps, they didn't just look like this in 2019. They look like this for years. Brings to the second fact that we're going to prove. They didn't fix it. Today, we're going to have to prove that the defendant failed to act like a reasonable company under similar circumstances. Today, we're going to call an expert witness, a professional engineer. You're going to hear her testimony by deposition. And she's going to tell you the obvious, that those stairs that we just saw, the concrete on them, they were dangerous. And the defendant needed to fix them. But today, it's going to be undisputed. Undisputed. That in the 15 years From the time the defendant opened that store until Miss Gilmore got hurt, the defendant didn't make a single repair to those steps. Didn't fix the concrete once. Not on the top step, not on the bottom step, not on any of them. Brings us to that last fact. Because the defendant didn't fix that dangerous condition, Miss Gilmore got hurt. Miss Gilmore, she's going to be the first witness that we call today. She's going to tell you about how she tried walking up those steps on the night of January 20th. How she was being careful. She had her hand on the wall to help her balance. She went to put her foot down on the landing, same landing where there was a hole in the concrete. And then she lost her footing. And then she fell. When Miss Gilmore's done testifying, it's going to be clear. The defendant is responsible because it was their dock, their steps, and their fault. Now, today, the defense, they're going to try and not accept responsibility. They're going to say, we didn't have to do any of the things. We didn't have to make any repairs. They might even try to blame somebody else. They might try to blame Miss Gilmore, say that she's the one who should have been more careful. Even though they ignored the dangers, they're going to say Miss Gilmore, she should have been careful enough to see them. Even though if they had fixed the steps, all of their employees would have been safe. At the end of this trial, it's going to be clear. Miss Gilmore fell off of those steps because they were dangerous. It'll be clear that she fell off the defendant's dock, off the defendant's steps, and that's the defendant's fault. That's why at the end of this trial, we'll ask you to return a verdict for Miss Gilmore. Thank you.
All right, thank you, counsel. Defense, would you like to present your opening statement now or reserve it for your case in chief?
Now, Your Honor.
Very well, you may proceed.
May it please the court. When there is no responsibility, there is no failure. Chimes department store had no responsibility to put guardrails on the loading dock. No responsibility to warn the plaintiff about the condition of a loading dock she had been on thousands of times. No responsibility for the plaintiff's actions while on a smoke break. Well, there is no responsibility, there is no failure. Chimes department store is a small family business right here in Waco. It's a department store just like JCPenney or Belt that sells a little bit of everything. Shoes, clothes, and tools. But it's just a local department store, not a national chain. The plaintiff was a cashier at Chimes department store for about 10 years. She was working on the evening of January 23rd of 2019 when she decided to take a smoke break out back. Employees had been told by Chimes not to smoke in front of the store where customers entered, but instead, if they wanted to smoke on the premises, they should smoke out back. So that night, the plaintiff and another employee, Riley Huntsberger, went out to the loading dock to smoke. The plaintiff walked to the bottom of these stairs leading down from the loading dock while Ms. Huntsberger stayed at the top with the door propped open. Plaintiff will admit that she did not have any trouble going down the stairs that night. But on the way back up, Ms. Huntsberger was holding the door open. And that door swings out into the path of the stairs. But the door wasn't flush up against the wall like it is right here in this picture. But Ms. Huntsberger was holding the door partially open, so it was blocking the plaintiff's way up the stairs. The plaintiff, moving away from the wall she had used to brace herself while going down the stairs, stepped towards the open end of the stairs, slipped while putting her right foot onto the landing, started to fall, and then jumped to the ground below, injuring her knee in the process. Because the plaintiff has brought this case against Chimes department stores the plaintiff has the burden of proving to you that the loading dock posed an unreasonable risk of harm, that Chimes knew or should have known that, and that Chimes failed to exercise ordinary care to protect the plaintiff by both failing to make the loading dock reasonably safe and failing to warn the plaintiff about the condition. Plaintiff will fail to meet that burden because the evidence will show us three things. One, the loading dock was not unreasonably dangerous. Two, the plaintiff knew about the condition of the loading dock. And three, it was the unfortunate and unforeseeable decisions of the plaintiff that caused her injuries, not Chimes department store. Now, the area from which the plaintiff fell was the loading dock. Employees like the plaintiff may have smoked from the dock, taken trash out on the dock, but regardless of that, this area was a loading dock, and every witness admits that. Even the plaintiff's hired expert admits that this area was used by Chimes as a loading dock and took this picture showing it being used as. But why is that important? We will call Perry Hayden by deposition. Mr. Hayden is a compliance officer with the Occupational Safety and Health Administration, better known as OSHA, the government agency that is responsible for making sure that workplaces are safe for the employees. To do that, OSHA has several regulations that govern the workplace, including regulations regarding loading docks. Mr. Hayden will tell you that OSHA regulations clearly state that guardrails are not required on loading docks because they are not feasible. Because Chimes was not required to have guardrails on the loading dock, the plaintiff will fail to prove that the loading dock was unreasonably dangerous. Plaintiff will also fail to prove that Chimes failed to warn the plaintiff about the condition of the loading dock. The plaintiff worked at Chimes for 10 years. And during those 10 years, the plaintiff went out onto the loading dock and down the stairs for smoke breaks, or to throw away trash a couple of times a day. By the plaintiff's own estimate, she went out on that loading dock at least 20 times per week. Plaintiff was very familiar with the entire loading dock area, and you will learn that the plaintiff was on notice for 10 years of the condition of the loading dock and the stairs. Finally, you will learn that it was the unfortunate and unforeseeable decisions of the plaintiff that caused her injury, not Chimes department store. When the plaintiff went out for her smoke break on January 23rd, it was already dark out. The plaintiff knew that the light by the loading dock could not be turned on from inside Chimes. The switch was located at another business, but the defendant still chose to go down the stairs out back in the dark. The plaintiff walked down the side of the stairs next to the wall with her hand on the wall to steady herself. But on the way back up the stairs, the plaintiff did not use the wall. Now, the plaintiff says that she did not use the wall because Ms. Huntsberger was holding the door open and it cut off the path closest to the wall. But the plaintiff did not ask Ms. Huntsberger to close the door. Did not ask Ms. Huntsberger to open the door all the way so it was against the wall and out of her way. The plaintiff did not move the door herself. Instead, the plaintiff chose to go around the door, away from the wall and near the edge of the stairs. Then, when the plaintiff stepped onto the loading dock and slipped, the plaintiff made the decision to jump to the ground. It was after the plaintiff jumped to the ground that the plaintiff was injured. Chimes department store had no responsibility to put guardrails on the loading dock. No responsibility to warn the plaintiff about the condition of a loading dock she had been on thousands of times. No responsibility for the plaintiff's actions while on a smoke break. Where there is no responsibility, there is no failure. Fined for Chimes department store.
Right. Let's proceed with the plaintiff's case in chief. Mr. Messina, would you like to call a witness?
We would, Your Honor. Plaintiff calls Jordan Gilmore.
All right, Ms. Gilmore, remind you that you've been sworn.
May I proceed?
You may.
Good afternoon. Can you say your name for the jury?
Jordan Gilmore,
Where do you live?
Waco, Texas.
What do you do for work?
I'm unemployed.
Well, where's the last place you were employed?
Chimes department store.
Well, what's the last day you worked for the defendant, Chimes Department Store?
January 23rd, 2019.
Why was January 23rd, 2019 the last day you worked there?
I was injured in an accident.
What kind of accident?
I fell.
Without going into too much detail, can you summarize your injuries for us?
Yes, I had a knee replacement and 28 staples, which
Objection,
resulted.
Your Honor. May we be heard outside the presence of the jury?
Yes.
The first part of the witness's answer goes to the plaintiff's necessary prima facie showing of injury in this negligence case. However, the number of staples in a leg or the size of any surgical wound or anything else the plaintiff was going to testify about goes to pain and suffering, long-term damages, and other things that are irrelevant in today's case that deals only with liability.
Response.
Your Honor, we do have to prove that there was an injury. A defense filed an answer that denied all allegations, including that Ms. Gilmore was injured. But I can rephrase the question, ask Ms. Gilmore to not talk about anything that happened after her surgery, just what happened to her knee on the night of January 23rd.
Okay, let's do that. With that idea, your objection is sustained.
Move to strike, Your Honor.
The testimony is stricken. The jury is directed to disregard.
Ms. Gilmore, without telling us what happened after you got hurt, can you tell us what injuries you sustained?
A knee injury.
I want to talk a little more about how you came to work at Chimes. So what was your job there?
I was a cashier.
On the night of January 23rd, what time did your shift start?
Noon.
Ms. Furlani, can we get Exhibit 2 up on the screen? You told us that you fell. Where were you when you fell?
I was walking up the stairs leading to the landing dock.
Is that the stairs in the loading dock that we see on the screen?
Yes, sir.
What were you doing back there on the loading dock?
I was taking a smoke break.
Why were you smoking on the loading dock?
That was in the area where we were allowed to smoke.
When you say allowed, what exactly do you mean?
The management said that if we wanted to smoke, we had to take a smoke break and do it in the back where customers couldn't see.
Well, I want to take a look at exactly what the defendant said. Can you open up Exhibit 1?
Yes.
Are you there?
Yes.
What's Exhibit 1?
That is a memorandum addressed to employees, and it came from Chimes management.
Is that a true and accurate copy of that memorandum you received from the defendant?
Yes, sir.
Plaintiff offers Exhibit 1 into evidence.
Any objection to Exhibit 1?
No objection, Your Honor.
1 is admitted.
Ms. Furlani, can we get Exhibit 1 on the screen? Ms. Gilmore, we see this memo is sent from Lane Kim. Who is that?
She is one of the managers at Chimes.
Who is this memorandum sent to?
Employees.
And what date was it sent?
July 1, 2015.
Now, in this memo, the defendant says the last time Reese came by the store, someone was smoking out front. We can't have that. Who's Reese?
Reese is the owner.
In the memo, the defendant says, as you have been told before, if you're going to smoke, you need to smoke out behind the store where the dumpster is. That's the only place you should take smoke breaks on the premises. Ms. Furlani, can we get Exhibit 2 again? Is this the loading dock and dumpster that the defendant was talking about in this memo?
Yes, sir.
Is this the same loading dock where you fell?
Yes.
Ms. Furlani, we can keep Exhibit 2 up for a moment. You told us a little bit about where you fell. Let's talk about how. What time of day did you fall?
Around 7 in the evening.
How dark was it?
Very dark.
Ms. Furlani is highlighting the platform on the loading dock. Is that where you were?
Yes.
Let me ask it this way. Is that where you were when you were smoking that night?
Initially, no,
Where were you smoking?
at the bottom of the steps.
Is that about where Ms. Verlani is putting an arrow?
That's correct.
Now, when you fell, were you going up these steps or down them?
I was going up.
I want to actually take a look at what those steps look like as you were trying to come up them. Ms. Verlani, can we get exhibit 3? Ms. Verlani is going to highlight an object that's on the right side of this photo. What is that?
That's a door.
Can you tell us how you fell?
Yes, so there was no light. Again, it was very dark. My coworker, Riley Huntsberger, was holding the door ajar. There was light coming from the store, but it was still obscured. I was just trying to make my way around. So I climbed up those stairs to try to get around that door. And then something happened where I lost my balance. I knew I was going to fall. So I kind of did a jump and I landed with my weight on the right side, on my right leg, and then I fell on my bottom.
Were you here for defendant's opening statement?
Yes,
Do you remember when they said that you fell because of decisions that you made?
yes, I do.
As you were coming up these steps, how careful were you being?
Very.
Well, as you were coming up these steps, were you running?
No,
As you were coming up these steps, were you scrolling on your phone?
no,
When you put your foot down and lost your balance, like you said, what step was that on?
it would be on that last step.
Is that the step that we see here with a hole?
Yes, sir.
I want to talk about what happened after you fell. After you fell, did you go back inside the store?
I did.
We saw that memo from Lane Kim earlier. Was Lane Kim still a manager at the store in 2019?
She was.
Was she working that night?
She was.
Did you speak to Lane Kim about what happened back behind the store on the steps?
Yes.
What did the defendant's manager say to you?
Yeah, we probably should have fixed those stairs a long time ago.
Thank you, Ms. Gilmore. Pass the witness.
Cross-examination?
Yes, Your Honor. Ms. Gilmore, you worked at Chom's department store for 10 years
Yes, sir.
as a cashier.
Yes.
While you worked for Chom's, you were a smoker.
Yes.
So you took smoke breaks while at work.
Yes.
So let's talk about those smoke breaks. You chose to take smoke breaks on the loading dock, right?
Yes.
You did not walk up the street to take smoke breaks.
Not up the street.
You chose to take your smoke breaks on the loading dock.
Yes.
Took at least one smoke break a day.
Yes.
You'd also go onto the loading dock to throw away trash.
I would throw trash in the dumpster, sir.
Yes, you would throw trash in the dumpster by the loading dock.
Correct.
And you went onto the loading dock down to get to that dumpster once or twice a day.
Correct.
Every day you worked.
Yes.
Say you went onto the loading dock about 20 times a week.
Correct.
You're pretty familiar with that whole area.
I am.
You were familiar with the stairs,
Yes.
familiar with the loading dock.
Yes.
Knew the stairs did not have a railing.
Correct.
Knew the loading dock did not have a railing.
Correct.
Said you never really thought about the loading dock not having a railing.
Yes.
Because like you've said, how could you put rails on a loading dock?
Yes.
You also knew that the light did not work.
Yes.
The light switch was actually in the Tractor Supply store, right?
Yes.
Not in Chimes.
Yes.
And the loading dock was in that same condition for as long as you worked at Chimes.
Yes.
Well, let's talk about the doors going out onto that loading dock. You would recognize pictures of those doors, right?
Yes.
Cited in court and opposing counsel what's already been admitted as Exhibit 6 and 7. Ms. Gilmore, you see my screen right there?
Yes, I do.
We're looking at Exhibit 6. You see that red sign in the middle of the door?
I do.
That sign reads, "Do not block, fire exit," right?
It does.
Now we're going to turn to Exhibit 7. See a strip of white on that actual silver push handle for the door.
I do.
Zooming in on that sign, it says alarmed emergency exit,
Yeah.
right? Your Honor, permission to preserve Exhibit 6 and 7 as plaintiff's demonstratives A and B.
Yes, you may.
Let's talk about the night of January 23rd of 2019. You went on a smoke break around 7 p.m.
I did.
And of course, at that time of night, it was dark at 7.
Yes,
As you said, you went on that loading dock to smoke many times before this.
I did.
Would go on the loading dock,
Right?
then walk down the stairs.
Yes.
Use the wall for support going down the stairs.
Yes.
Smoke your cigarette.
Yes.
Walk back up the stairs.
Yes.
Again, using the wall for your support.
Right.
And during those 10 years, you never had a problem going down the stairs.
No.
During those 10 years, you never had a problem going up the stairs.
No.
At least not until January 23rd of 2019.
Correct.
And that night, you went on your smoke break with Riley Huntsberger.
Correct.
Miss Huntsberger stayed at the top of the stairs
Yes.
while you went down,
Yes.
again, using the wall for support
Yes.
without any problem.
Yes.
And after you finish smoking, you go back upstairs.
Yes.
Miss Huntsberger was still holding the door open,
Yes.
about halfway open.
Yes.
So the door was blocking your way closest to the wall.
Yes.
You did not ask Miss Huntsberger to close the door.
I did not.
Did not ask Miss Huntsberger to open the door all the way.
No.
Open all the way so the door will be flush up against the wall
No.
and out of your path.
Right. I did not.
You did not close or open the door yourself.
I did not.
You chose to go around the door.
Right.
Chose to move away from the wall.
Right.
Chose to move towards the edge of the stairs.
Right.
You claim you started to slip.
I lost my balance. That's correct.
And when you lost your balance, that's when you jumped from the loading dock, right?
Yes. I knew I would fall.
Miss Gilmore, just to be sure, at the time that you jumped from the loading dock, you were 47.
It was 2019.
Yes.
Yes.
But you still chose to jump from the loading dock.
Given that I had lost my footing. Yes.
But you jumped from the loading dock to the ground,
Right.
not towards the wall,
No.
not further up the loading dock,
No.
but back towards the ground.
Right.
And that's when you were injured.
Correct.
Pass the witness, Your Honor.
All right, any redirect?
Yes, Your Honor, just a couple of questions.
Proceed.
Ms. Gilmore, you were just asked by defense counsel about why and which direction you jumped off of those steps. I want to make sure you have a chance to answer. Why did you jump off the steps?
Because I had lost my footing, I knew that I was going to fall. And so I jumped hoping that I would land on my 2 feet.
Why didn't you jump towards the wall?
Well, I couldn't with Riley so close and the door being where it was.
Thank you, Ms. Gilmore. Pass the witness.
Okay, anything further from this witness? Any recross?
No, Your Honor.
All right, may this witness be excused?
Yes, Your Honor, nothing else from the plaintiff.
All right, you're excused. Do you have any other witnesses, Mr. Nacino?
Now that we're going to call live, Your Honor, we do want to call a witness by deposition, Kelly Danes. She's stipulated unavailable under Rule 804A, and her her testimony is accepted from the rule against hearsay under Rule 804B1, former testimony.
Okay.
We provided a highlighted copy of the deposition with the portions we're going to read highlighted to defense counsel before trial. Is it okay if Ms. Ferlani appears on screen to read the witness's answers?
Of course.
And Your Honor, can we assume that you're going to instruct the jury on what deposition testimony is?
Yes, the jury has been constructively instructed.
Thank you, Your Honor. Starting from page 2, line 6. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Kelly Danes.
Page 3, line 13. What do you do professionally?
I'm the president of Danes Engineering, LLC.
What does your company do?
We provide forensic and investigative engineering consulting and litigation support, specializing in industrial, commercial, and construction engineering, operations, safety, patents, and regulations. So basically, we help to investigate engineering issues in those fields throughout the United States, mostly connected to lawsuits like this one.
Page 5, line 14. All right, Kelly, I want to move on and talk about your work in this case. What did you review in coming to your opinions in this case?
I reviewed the deposition of Jordan Gilmore, the deposition of Reese Geller, a number of different regulations from the Occupational Safety and Health Administration, a number of provisions from the International Building Code, and I conducted an inspection of the location of the fall and took pictures of that area.
Page 6, line 14. Are exhibits 16 through 21 fair and accurate depictions of how that area looked at the time of Jordan Gilmore's fall?
Yes. Well, it was dark when she fell, but other than that, this is the same area and how it looked.
Well, what do these pictures show?
Well, as you can see, there are no railings on the steps up to the landing area, and there is no railing on the landing area itself. Plus, you can see where the railing used to go into the concrete and how the concrete around those areas is worn down and cracked. So you can see that this is a pretty dangerous situation.
That's all from us on this witness, Your Honor.
All right, Mr. Banks, would you like to read in any testimony from this witness?
Yes, Your Honor.
Okay, you may proceed.
Citing court and counsel to page 3, line 22 through page 4 at line 4. Based on what you do for a living, is it fair to assume that you regularly testify in lawsuits?
Yes, no question about it. I testify and work as an expert on cases on a regular basis. To be honest, preparing expert opinions in lawsuits like this one, testifying in depositions, and testifying at trials are about 99% of what I do at this point.
Citing court and counsel to page 4, line 21 through page 5 at line 10. How'd you get involved in this case?
I got a call from the firm representing the plaintiff, Jordan Gilmore. It's a firm that I've done work for in the past, so this isn't the first time that I've consulted in one of their cases.
I guess that means they liked what you did in those other cases.
What can I say? I'm good at what I do.
Kelly, I'm showing you what has been marked as Exhibit 15. Do you recognize this?
Yes, it is the invoice for the work that I've done so far on this case, which obviously doesn't include my time today or my time testifying at trial if I have to do that.
Is Exhibit 15 a true and correct copy of the invoice for your work on this case up to this point?
Yes, it is.
Citing court and counsel to page 10, lines 19 through 23. Do the OSHA regulations place any requirements on employees?
Yes, there is a general duty requirement in 29 USCS section 654B, which says that employees also have to comply with the OSHA standards and regulations, and basically have to be responsible for their own actions.
Citing court and counsel to page 11, line 24 through page 12 at line 7. What's next?
Next, we move to OSHA 1910-23D1 and 1910.24H and IBC 1009.11.
Why are those significant?
All of these provisions require that stairways or flights of stairs must have guardrails or railings on any exposed side. Here, there was no guardrail on these stairs on the exposed side, which is obviously dangerous.
Citing court and counsel to page 13, line 16 through page 14 at line 4. All right, anything else?
Let's take a look at OSHA 1910.24H and IBC 1012.1. 1910.24H requires railings on all stair platforms, and 1012.1 requires guardrails on all landings that are located more than 30 inches above the ground. In this case, as you can see from the photographs, I measured the distance from the ground to the top of that landing, and it was 34 inches. So this landing would be subject to both standards. Again, like we discussed earlier, this landing had a guardrail at one point, and it was removed. And depending on exactly where the plaintiff fell, if the stair handrail didn't provide enough protection, then a guardrail around the landing would have given her something to grab onto to keep from falling.
Citing court and counsel to page 14, lines 12 through 17. You would agree, though, that this area was used by Chimes as a loading dock at times.
Yes, at times.
And a guardrail around that loading dock would certainly inhibit Chimes' ability to use it as a loading dock.
Yes, it would make it difficult.
No further portions to be read in at this time, Your Honor. However, under Rule 705 of the Federal Rules of Evidence, defense seeks to read in OSHA's statute 1910.24A and H with the expert relied on.
Any objection to that?
Under 705, no objection with that, Your Honor.
All right, you may read it.
Mr. Davis, if you pull up 1910.24H. Part H, railings and handrails. Standard railings shall be provided on the open sides of all exposed stairways and stair platforms. Handrails shall be provided on at least one side of closed stairways, preferably on the right side descending. Stair railings and hand railings shall be installed in accordance with the provisions of section 1910.23. Your Honor, at this time, defense seeks to constructively read in section 1910.23C.
All right, it's constructively read.
Mr. Davis, if you pull up 1910.24A. Application of requirements. This section contains specifications for the safe design and construction of fixed general industrial stairs. This classification includes interior and exterior stairs around machinery, tanks, and other equipment, and stairs leading to or from floors, platforms, or pits. This section does not apply to stairs used for fire exit purposes, to construction operations to private residences, or to articulated stairs, such as may be installed on floating roof tanks or on dock facilities, the angle of which changes with the rise and fall of base support. Pass the witness, Your Honor.
Okay, is there anything further on this deposition?
Not from the plaintiff, Your Honor.
Okay, are there any further witnesses from the plaintiff?
There are not, Your Honor. Plaintiff rests.
All right, before we move to the defense case in chief, are there any motions that need to be brought to the attention of the court before we proceed?
Yes, Your Honor. This time, defense moves pursuant to Federal Rule of Civil Procedure 50 for the judgment as a matter of law. Even when viewing the facts in a light most favorable to the plaintiff, no reasonable juror could conclude that they have met their burden of proof on this negligence claim against Chimes Department Store. As was just read, Your Honor, the OSHA regulations as applied to employers have been met, as fire exit stairs as exhibited by exhibits 6 and 7 do not require handrails. Further, Your Honor, plaintiff's own expert stated that the purpose of a loading dock would be defeated by the installation of handrails, which the back area was. And by that alone, Your Honor, the plaintiff cannot prove that there was negligence based on unreasonable upkeep of the area.
All right, response.
Your Honor, defense's motion was based around the idea of guardrails. We actually haven't advanced that today in trial. So viewing the evidence in light most favorable to us, the non-moving party, a rational juror could find that we've met our burden of proving there was a dangerous condition. And for us, what we've shown today is that dangerous condition was the condition of the concrete on those steps, the gaping holes that we saw in photos that the jury saw, the cracks, the eroded parts, the pieces where chunks of concrete were missing, the pieces and the step that Ms. Gilmore said that's where she stepped just before she slipped. The jury's seen those photos. A rational juror could certainly find that that was an unreasonably dangerous condition. And we read onto the record, testimony from a professional engineer, an expert in engineering, who said the steps were dangerous. We certainly met our burden of showing there was an unreasonably dangerous condition.
All right, Mr. Banks, your arguments are well taken, will received by the court. I will deny your motion.
Yes, Your Honor.
Before we proceed with the defense case in chief, let's take a 10-minute break. It's 3:46 Central Time. If everyone would be back at 3:56, we will proceed. And when you get back, scoring judges, please turn on your camera so that we know you're here. Thank you very much. Right. All right, do we have everybody back? Let's see. Not quite. Looks like we're still waiting on one scoring judge, so just bear with us a second. Hey, Brad, do you have Sammy's number?
Sorry, Judge. I do not.
Okay, let me go see if I can get somebody to call him. Oh, all right. All right, looks like we have everybody back. So the scoring judges, thank you. You can close your screen. All right, Mr. Banks, are you ready to proceed with the defense case in chief?
Yes, Your Honor. This time, defense calls, excuse me, Your Honor, rescaler to the stand.
All right, remind you that you've been sworn.
Ms. Gaylor, I think you're still muted. There you go. Please introduce yourself to us.
Hi, my name is Reese Geller.
Ms. Gaylor, before we get too far into this, I'd like for the jury to get to know you a little bit better. Excuse me for asking, but how old are you?
I'm 45 years old.
Where are you from?
I'm from right here in Waco, Texas.
How long have you lived in Waco?
For my whole life, born and raised here in Waco.
Since you've been in Waco your whole life, have you worked in any places in town?
I have at Chimes department store.
Where's Chimes located?
It's just off of Bosque Avenue.
What is Chimes?
Chimes is a department store, you know, like to compare it to JCPenney or Macy's.
Now, is it a national chain like those, or is it different?
It's different. We're a small mom and pop type department store.
How long has Chimes been around?
Oh, it's been a very long time. My grandparents started Chimes and it's become, you know, a family business for us.
Now, you said you went to work at your family store. About how long ago was that?
Ooh, it was about 23 years ago now.
What jobs have you held while you were working at Chimes?
Well, I started at Chimes as a buyer, so I would purchase the merchandise that we would ultimately sell in our store.
You said you start in the buyer's department. Are you in a different area now?
Yes, I'm now the current owner of Chimes.
How long have you been the owner?
It's been about 10 years now.
Ms. Geller, we're here because the plaintiff is suing Chimes for injuries she received outside of your store. Are you aware of the area where the plaintiff was injured?
Yes, I am.
And what area was that?
The loading dock area.
Why would the plaintiff have been out back at that time of night?
Well, we instruct our employees to take smoke breaks out there and dispose of the trash out there as well.
Why would you tell employees to smoke in that area?
Well, as a mom and pop family type store, we don't want people smoking out in front of our business.
Would you recognize photos of that loading dock area if I showed them to you?
I would.
Citing court and counsel, what's already been admitted as Exhibit 6, 7, and 19. Ms. Geller, I've got Exhibit 6 up for you. Do you see that?
I do.
Now, looking at that red box in the middle of the door, can you read that out for us?
Do not block fire exit.
We're going to look at Exhibit 7, directing you to that silver handle in the middle of the door. Can you read what that sign stands for us?
It says alarmed emergency exit.
Now, were the back doors leading out to that loading dock emergency exits?
Yes, they were.
Ms. Geller, now looking at Exhibit 19. Now, looking at Exhibit 19 here, do you see any rails around that area?
I do not.
Have there ever been rails around those stairs of that loading dock?
Yes.
Why were they removed?
They were removed so that we could implement a loading dock.
How did you get those rails removed?
We sent an email request to our landlord requesting that they remove the guardrails.
Have Chimes used this area as a loading dock for the whole time it's been in this location?
It has.
And just to be clear, why would you need to take down those rails for a loading dock?
Well, in order to use the area as a loading dock. The rails needed to be removed so that we can work in that area and take the merchandise from the truck and bring it into our storage room.
Pass the witness, Your Honor.
All right, cross-examination?
Your Honor, before I begin, can we be heard at sidebar?
Yes.
And this pertains to the 2010 incident that we talked about before trial. We intend to ask Ms. Geller some questions about that incident. I want to talk about it with you first, like you instructed us.
Okay. Do you still have an objection, Mr. Banks, to that testimony?
Yes, Your Honor. I stand on my prior grounds, as well as there was no door open during the direct examination.
Okay, and why is this evidence relevant to the case today, Mr. Messino?
Sure, and Your Honor, it might help if I make an offer of proof as to what I want to do.
Okay.
I want to introduce it's Exhibit 14. This is a written document prepared by a supervisor and manager for the defendant back in 2010 about that incident. In that document, the employee reported to defendant's management that they had slipped on what they think was loose concrete on those back steps. We want to introduce that exhibit, that information, and then ask this witness about what they did in response to that, how they didn't repair the steps, how they didn't fix any of that concrete. And so that's why this is relevant to this case. It goes to 1, the dangerous condition existing, and 2, the defendant's failure to act like a reasonable company by deciding not to fix it.
And so let me ask you, is the dangerous condition that you're alleging injured the plaintiff in this case the same dangerous condition that caused this alleged other incident?
We believe it is, Your Honor. The way the concrete was on the steps, the fact that some of it was loose, that there were holes in it.
Okay. I'll let you have one final response to that, Mr. Banks, before I
Yes,
rule.
Your Honor. As to Exhibit 14, not only is the document itself is hearsay, but the contents of that contain additional layers of hearsay, part of which is based on speculation by the other employee guessing as to what might have been wrong with the steps at the time. Further, Your Honor, the defense's position is that the step this prior instance reference is not the same step at the top of the stairwell that this plaintiff slipped on while walking up, where this prior instance, the employee was walking down and suffered minor injuries.
Okay. At this point, Mr. Banks, I will overrule your objection to the testimony. When I'll withhold ruling about the admissibility of the document until it's offered into evidence, and I can actually take a look at it.
Yes, Your Honor.
All right.
May I proceed?
Go ahead, sir.
Yes, Your Honor. Good afternoon, Ms. Geller. I want to start by talking about what you and your company knew about that loading dock. Ms. Furlani, can we get Exhibit 2 back on the screen? This is that loading dock behind your store.
Correct, yes.
You have employees coming in and out of that door, right?
Yes,
Loading packages,
yes,
taking out trash.
yes,
It's the same loading dock where Ms. Gilmore fell.
correct,
Same loading dock where she got hurt.
yes,
Now, I heard something you said on direct examination. You said this was an emergency exit.
yes,
We saw that little handle of the door. It said alarmed emergency exit.
yes,
Ms. Geller, like you just told us, employees use this door all the time.
yes,
They used it every day,
yes,
coming and going,
yes,
doing their job at your store.
yes,
Now, you moved into this building in 2005.
that's correct.
You knew people were going to be on this loading dock.
Yes,
And Ms. Geller, you'd agree, you're a pretty smart businesswoman.
I like to think so.
You've been a business owner for more than 10 years.
Yes,
You didn't want anyone to get hurt on this loading dock.
correct.
You didn't want anyone to fall.
Yes,
I want to talk a little more about whether you knew that loading dock was dangerous. Can you open up Exhibit 14? Let me know when you're there.
I'm there.
Exhibit 14, that's a document that was created by a supervisor for your company.
That is correct.
It describes an accident that happened at your store,
Yes.
an accident on those same steps.
Yes.
It's a true and accurate copy of that statement.
Yes.
Plaintiff offers Exhibit 14.
Objection?
Yes, Your Honor. At this point, while opposing counsel might have gotten around the first layer of hearsay, there are still additional statements within this document that also constitute hearsay, as well as speculation in that document.
Okay. First, Mr. Nacino, speak to the hearsay, and maybe we would need Mr. Banks to point out which statements he's claiming are hearsay within hearsay.
Sure, Your Honor. It sounded like to me that the defense just agreed that the document itself, the four corners of it, they're exempt from the hearsay rule under 801 D2D. It was a document created by an employee and agent of the party within the scope of their employment. As to other statements within that document, we believe that those also qualify or exempt from the hearsay rule under 801 D2D. Statements by an employee on a matter that happened within the scope of his employment, describing the accident that happened to him while he was working for the defendant. And if the court's not convinced about that, the statements are certainly being offered for notice and knowledge of the defendant company. It's an employee of them who fell on their property describing what happened.
Okay, could you share the document with me? We'll consider this outside the presence of the jury.
Yeah, I think Ms. Verlani is doing that now.
Okay, Mr. Banks, what hearsay within hearsay statements are on here, and how do you respond to Mr. Nacino's argument that those are also exempt as admissions by party opponent?
Your Honor, every emboldened part of this document is the employee filling out as their statement within this larger document. Your Honor, the employee in this instance was a cashier, not a safety officer, not another manager, that was filling out this accident loss. Where were you when the accident happened? And as such is not a part or during the scope and line of their employment as a cashier for this defendant.
Okay, Mr. Nacino, what's your response to that, that this was not kind of a course and scope issue?
Well, Your Honor, we think that it is describing a matter that happened within the scope of that employment. We heard that employees, cashiers like Ms. Gilmore herself, go up and down those stairs all the time. It's a pretty regular thing they do in their employment, taking out trash sometimes, loading boxes sometimes. So we think it does satisfy 801 D2D and is exempt from the hearsay rule. But I didn't hear defense respond. And if the court's not convinced, this is being offered not for its truth, but for the effect that it would have had on defendant company, the notice that it should have put them on that there was a dangerous condition, and to the lack of subsequent action they took.
Okay, I am going to overrule the objection. 14 is admitted.
Yes, Your
And Your Honor, is it admitted for the truth it asserts as well, or just for the effect?
It's admitted for all purposes.
Yes, Your Honor. Ms. Verlani, can we get Exhibit 14 back on the screen? Ms. Geller, this is a report from one of your employees and one of your supervisors, right?
Yes, it is.
Describes an accident that happened at your store.
It does.
The employee says they fell at about 7 p.m.
Yes.
In this report, the employee says, I was out back on the loading dock. My supervisor asked me to take out some trash and throw it in the dumpster. That's that same loading dock and dumpster that we saw earlier.
That is correct.
The employee says, she told me to just leave the door open and use the light from inside the building so I could see where I was stepping. That's the door that we've seen in Exhibit 2, Exhibit 6, and Exhibit 7, right?
Yes.
The employee says, I did exactly that. But as I was walking down the steps, I slipped on what I think was loose concrete, and I fell face first onto the ground at the bottom of the steps. Ms. Geller, this happened about 9 years before Ms. Gilmore fell.
Yes.
In those 9 years, you didn't make any repairs to the steps.
No,
You didn't fix any of that concrete.
no,
Defense counsel, they talked a little about warnings earlier. You didn't put up a sign that said loose concrete.
no,
You didn't put up a sign that said watch your step.
no,
You didn't have your managers to tell employees, hey, if you're not loading packages, stay off the loading dock.
no.
I want to talk a little about the consequences of that. Ms. Fulani, can we get Exhibit 3 up? This is another angle of the door and steps behind your store.
Yes,
We see here that the door, it's open.
it is.
When the door's open like this, there's not a lot of room to get by on those steps.
No,
But we can see in this photo, the steps, they have a hole in them.
yes,
There's places on the steps where chunks of concrete are missing.
yes,
Places where the step just ain't there anymore.
yes,
Now, you started leasing this property in 2005.
that's correct.
From the time you started leasing this property until Ms. Gilmore's accident, you don't have any records of any repairs you made to these steps.
To my knowledge, that's correct.
And then what happened on January 23rd is Ms. Gilmore was coming up the steps that night.
She fell.
She was coming up the steps when she fell, right?
I'm sorry?
She was coming up the steps when she fell, right?
Based on the facts that, based on her statements, that's what she's alleging, yes.
Coming up the steps when she fell at about 7 p.m. That's what she said.
Yes, that's what she has said.
Just like that incident back in 2010.
Somewhat, yes.
When she was coming up these steps, she put her foot on this step with a hole in it.
That is what she's saying, yes.
She said when she put her foot on that step, she lost her footing.
Yes, that's what she said.
She said she fell.
That's what she said, yes.
She said she got hurt,
That is what she said, yes.
just like that person back in 2010.
Yes.
Ask the witness, Your Honor.
Can you redirect?
Yes, Your Honor.
Okay, you may proceed.
Ms. Gaylor, who took the rail down?
That would be the landlord.
And who took care of the concrete back there?
That would be the landlord.
Why would you send employees out back to that loading dock area?
Because that's where employees were to take their smoke breaks and to dispose of trash and to use the loading dock.
And in your time since being in that location in 2005, besides 2010 and 2019 instances, has been any other employee to complain about a fall on those back steps?
To my knowledge, there is not.
Are there any records of any complaints about that?
No.
Pass the witness, Your Honor.
Anything further from this witness?
I do have a couple questions on that, Your Honor.
Okay, give me 1 second.
Yeah.
Okay, you may proceed.
Ms. Geller, you were just asked about the landlord fixing the concrete back on those steps. You could have asked your landlord to fix the concrete, right?
I suppose, yes.
You didn't do that.
No.
You hadn't contacted your landlord about those back steps since 2005.
Correct.
That's almost 15 years.
Yes.
Ask the witness.
All right. May this witness be excused?
Yes, Your Honor.
All right, thank you, ma'am. Are there any further witnesses for the defense?
Your Honor, at this time, the defense calls Perry Hayden by deposition. May I read the questions of the portions of the deposition we are offering, and may my co-counsel, Mr. Davis, read the answer to those questions?
Yes.
May we constructively consider the jury to have been instructed that the previous instruction regarding depositions also applies to this witness?
Jury is so instructed.
One moment while my co-counsel gets set up, Your Honor. Citing court and counsel, to page 2, lines 5 and 6. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Perry Hayden.
Citing court and counsel to page 2, lines 11 through page 3, line 3. What do you do for a living?
I'm a compliance safety and health officer with the Occupational Safety and Health Administration.
What does the Occupational Safety and Health Administration, or OSHA, do?
OSHA is the government agency that is responsible for making sure that workplaces are safe for the employees that work there. So we provide training, we provide information, training, and assistance to employees and employers to try to make workplaces as safe as possible and to make sure those workplaces are in compliance with OSHA regulations and standards. We're all about employee safety.
And what do you do at OSHA as a compliance, safety, and health officer?
I'm one of the people from OSHA that goes out and inspects workplaces on a regular basis to see if that workplace is in compliance with OSHA standards.
Citing court and counsel to page 3, line 16 through page 4, line 13. How long have you worked for OSHA?
Since I got out of school. So at this point, that's about 13 years.
And over that time, how many inspections have you conducted?
Oh man, hundreds, thousands. I mean, the answer is a lot. It's basically my entire job. So I'm always out on the road inspecting somewhere. It's an everyday thing.
What kind of education did you receive before becoming an inspector for OSHA?
I graduated from high school and then I went on to Texas State Technical College where I got an associate's degree in occupational safety compliance technology. Then I went on and got a second associate's degree in environmental technology compliance.
What are those degrees about?
Well, these are really training programs dealing with the hazards of machines, safe work methods, environmental hazards, workplace hazards, and various safety issues. These are literally the degrees you need if you want to do something like work for OSHA. That's why I got them, because I figured working for OSHA would be a good, steady job.
Have you ever testified in a lawsuit before?
No, first time.
Citing court and counsel to page 5, lines 1 and 2. Are you being paid by anyone for your time here today?
Nope.
Citing court and counsel to page 8, lines 20 through page 9, line 22. Is there any OSHA regulation that does specifically discuss loading docks?
Yes, 1910.28 B13 clearly states that guardrails aren't required on loading docks because they aren't feasible. You can't very well load something onto the dock with a bar in your way.
Have you had a chance to review the deposition of Kelly Danes?
Yes, I have.
Well, what do you have to say about all of the OSHA regulations that Kelly Danes testified were violated by the defendant because of the condition of that landing area in the back of the store?
I'm sure Miss Danes is a very nice person, but they're just reading those regulations too broadly. None of them deal with loading docks, which is what Chimes was using this area as. This wasn't just a stairwell or just a landing area at the top of a stairwell. This was a loading dock. And the provisions cited by Kelly Danes don't deal with loading docks.
Was this area behind the store exclusively used as a loading dock?
No, it is my understanding that employees also went out there to throw trash in the dumpster and to take breaks. And it is certainly possible that employees went out there and did other things as well, but I don't think that matters.
Why not?
Well, just because an employee goes out and sits on the edge of a loading dock and eats a sandwich doesn't make that loading dock a diner. The key thing here is that Chimes use this area as a loading dock. That's what matters.
Your Honor, defense moves to constructively read in page 6, line 8 through page 7, line 19.
Very well.
Pass the witness, Your Honor.
All right. Plaintiff, would you like to read anything from this deposition?
Just a couple of things, Your Honor. Ms. Ferlani is going to appear there, read the witness's answers.
Okay.
From page 6, line 22. When you went out there, what did you notice about the steps and that landing area?
Well, at first I was a bit alarmed because there was some pretty obvious issues.
Like what?
Well, there were stairs and a landing area, but there were no guardrails anywhere. Plus, the concrete on the edge of those steps and that landing were cracked and eroding away. Someone with half as much experience as me could look at that and see some pretty obvious problems.
That's all from us, Your Honor.
All right, anything further on this deposition?
Yes, Your Honor. Defense moves to constructively read in page 7, line 9 through 19.
Okay,
Nothing further from this witness, Your Honor. The defense rests.
all right. If there are no further defense witnesses, plaintiff, do you have a rebuttal case to put on?
We don't, Your Honor. We're ready to go to closing argument.
All right, and then Mr. Nacino, do you close the evidence?
Yes.
Mr. Banks, does the defense close the evidence?
Yes, Your Honor.
Are there any matters that need to be taken up outside the presence of the jury before closing arguments in the charge?
At this time, defense renews its Rule 50, judgment as a matter of law under the Federal Rules of Civil Procedure.
It's denied.
Yes, Your Honor.
Would either side like any time to prepare for closing?
Yes, Your Honor.
Okay, is 5 minutes sufficient or would you like more?
5 is good with me, Your Honor.
All right, it's 4:28 p.m. So let's be back here at 4:33. And again, if the scoring judges and everybody would turn on their camera at that time.
Yes, Your Honor.
In recess. Thank you. All right, it looks like we have all 4 judges back. Are the parties ready to proceed?
Plaintiff's ready, Your Honor.
Yes, Your Honor.
Okay, would anybody like to know how much time they have left?
Yes, Your Honor.
Okay, I'm going to tell you how much, and then I'm going to instruct you not to use it all. Plaintiff, you have 30 minutes and 11 seconds, and defendant, you have 28 minutes and 13 seconds.
Yes, Your Honor.
All right, you may proceed.
Not going to use it all, Your Honor. Before I begin, we're planning on displaying some exhibits that were admitted during the trial. Is it also okay if we display some portions of the jury instructions?
Of course.
Thank you, Your Honor. May I please the court?
Counsel.
An employee is standing on the defendant's loading dock. The employee takes a step onto a hole, onto broken concrete, onto a place where the concrete is loose. The employee slips, falls, gets hurt. Members of the jury, that's the story of what happened to Miss Gilmore in January 2019. But it's also the story of what happened in January of 2010. And what we heard is that after January 2010, the defendant didn't fix the holes, didn't fix the steps, didn't fix any of that concrete. Not in 2010, not in 2011, not ever. And the worst part of the defendant's choice to maintain those steps poorly is that the injuries to Miss Gilmore, they're permanent. And the evidence has shown that the defendant, they're responsible for those injuries because it was their dock. Those were their steps, and it was their fault. Of course, it wasn't good enough for us to just tell you the defendant's responsible. We had to prove it. And we had to prove it by a preponderance of the evidence. And we've met that burden by proving the 3 facts that we mentioned back in opening statement. Let's take them one at a time. Fact 1, there was a dangerous condition. As the judge will instruct you, we had to prove that there was a dangerous condition on the defendant's property. That means there was something about their property that created a substantial risk of harm. So we saw the defendant's loading dock. And we saw the steps on those loading dock with concrete that was broken, with holes in the top steps and the bottom steps, with chunks of concrete missing, cracks that were worn and steps that were weathered. And if it wasn't obvious enough, you heard testimony from an expert in engineering, Kelly Danes, who told you, yeah, these steps, the concrete here, that was dangerous. And the defense's own expert, that OSHA investigator that they read testimony from, well, they also thought that those steps were dangerous. This is from their testimony. The concrete on the edges of those steps and that landing were cracked and eroding away. Someone with half as much experience as me could look at that and see some pretty obvious problems. But it's not just that the steps were dangerous in 2019. We heard the defendant knew they were dangerous back in 2010. We saw this report where an employee for the defendant told their supervisor, I got hurt on those steps. I think I slipped on some loose concrete and I fell on my face. And what was defense counsel's response to all this? They didn't really have much to say about the concrete. about the cracks, about the holes in the steps. They wanted to talk about railings. They wanted to talk about, well, is this a loading dock? Is it not a loading dock? They wanted to talk about emergency exits. Members of the jury, the reason defense counsel didn't want to talk much about that concrete is because they know those steps, they were dangerous. They created an unreasonable risk of harm. Brings us to the second fact we had to prove. The defendant, they didn't fix it. Today, we heard about everything the defendant knew. How they knew in 2010 that those steps were a problem. And as the judge will explain, we had to prove that the defendant was negligent, that they failed to act like a reasonable, ordinary company in the same or similar circumstances. So what would an ordinary company in those same circumstances do after getting that report from 2010? Well, they certainly would have done something. Not the nothing that the defendant did. We heard they didn't fix any of those steps, didn't fix any of the concrete, didn't patch any of those holes. And they didn't put up any signs to warn their employees, to let them know, hey, watch your step. You might trip. You might slip. You might fall and get hurt. Brings us to that last fact we had to prove. That dangerous condition caused Ms. Gilmore's injuries. As the judge will explain, causation, it has two parts. First, we had to prove that the defendant and their negligence was a substantial factor in Ms. Gilmore falling and getting hurt. We heard that Ms. Gilmore, she put her foot on that top landing where there was a hole in the concrete. And she lost her footing. She slipped and she fell backwards. Of course, these steps were a substantial factor. We also had to prove that it was foreseeable. It was foreseeable, given these steps, that someone was going to get hurt. Members of the jury, if you keep steps that have a big hole in them, that have chunks missing, that have loose concrete, yeah, it's foreseeable that someone might slip. Someone might fall. And it's especially foreseeable when it's happened before. This is the jury verdict form. Because we've proved those three facts. Because we've met our burden. And because we've proved it was their dock and their steps. You can find that it was their fault by writing yes on question 1 next to Chimes department store. But there's still more that we need to talk about before you finish that form. And that's because for the defense, when their railings and when they're loading docks and their emergency exits, when all that didn't work, they actually tried to blame Ms. Gilmore herself. And on this, they have the burden of proof. Ms. Gilmore, she's being held to an ordinary person standard. She had to act like a reasonable person in the same or similar circumstances. And the evidence we heard today is that while Ms. Gilmore was walking up those steps, she was being careful. She was being cautious. She told you she had her hand on the wall to help guide her in the dark. She wasn't running up the steps. She wasn't distracted on her phone. She was doing her best to watch her step in the darkness. That's careful. And it's certainly not negligent. And so when you get that verdict form for question 1, you can write no next to Jordan Gilmore. Members of the jury, in a moment, defense counsel is going to get up and they're going to try to continue to make excuses for their company's conduct. And when they do that, I want you to remember the words of the defendant's manager on the night of January 23rd, when she learned that Miss Gilmore fell on those steps. It wasn't a response of shock. It wasn't a response of surprise. It wasn't a response of blaming Miss Gilmore. It was, yeah, we should have fixed those steps a long time ago. And yeah, we agree. The defendant, they should have. And so when you go back to deliberate, we're asking you to find a verdict for the plaintiff. Because it was the defendant's dock, the defendant's steps, and the defendant's fault. Thank you.
Thank you, counsel. Defense, you may proceed.
May it please the court. Chimes Department Store is not responsible for the actions of the plaintiff while she was on a smoke break. Where there is no responsibility, there is no failure. Chimes Department Store had no responsibility to put guardrails on the loading dock, no responsibility to warn the plaintiff about the condition of a loading dock she had been on thousands of times, and no responsibility for the plaintiff's actions while on a smoke break. Members of the jury, today the plaintiff failed to prove that Chimes had a responsibility to do any of these things. And because they could not prove a responsibility, it is impossible for the plaintiff to prove to you a failure by Chimes. Whereas there is no responsibility, there is no failure. It is unfortunate that Ms. Gilmore was injured. No one here today is overlooking that. But members of the jury, just because Ms. Gilmore was injured while she was working for Chimes does not mean that Chimes is to blame. Because the plaintiff has brought this case against Chimes Department Stores, the plaintiff has the burden of proof. The burden of proving to you that the loading dock posed an unreasonable risk of harm, that Chimes knew or should have known that, and that Chimes failed to exercise ordinary care to protect the plaintiff by both failing to make the loading dock reasonably safe and failing to warn the plaintiff about the condition. Plaintiff had all day to prove those elements to you. Plaintiff failed. Failed because the evidence has shown that the loading dock was not unreasonably dangerous. Plaintiff knew about the condition of the loading dock. That was the unfortunate and unforeseeable decisions of the plaintiff that caused her injuries, not Chimes Department Store. Let's look at those one at a time. First, the evidence today has shown that the loading dock was not unreasonably dangerous. But how do we know that? Loading docks do not and cannot have rails. You can't put boxes filled with merchandise through rails on a loading dock. It's a loading dock, so you must consider what it's used for. Unloading trucks onto the dock to move boxes into the store. When deciding whether the dock was unreasonably dangerous. And as Perry Hayden, the OSHA safety inspector, said, it is not feasible to put rails around a loading dock. Saying a loading dock needs a rail is like saying a NASCAR car needs a governor to hold their speed to 55 miles an hour. Race cars are supposed to go fast. We all recognize that. So holding their speed defeats their purpose. Loading docks are for loading. Adding rails defeats their purpose. The plaintiff has tried to play on emotions by showing you this dock with no rails and where the rails used to be. But the judge will tell you to prove negligence, the plaintiff has to prove that Chimes failed to use ordinary care. Loading dock simply will not work and cannot function with a railing on it. Because no ordinary prudent store owner has railings on their loading dock or would put railings on their loading dock. The plaintiff has failed to prove the loading dock was unreasonably dangerous. Failed to prove negligence. But the plaintiff brought their hired gun in here to tell you a loading dock should have railings. Not only does that not make sense, but Ms. Daines is just wrong. We know that Ms. Daines is wrong because of Perry Hayden. The OSHA safety investigator told us that loading docks are not required to have railings because it is not feasible to require that loading docks have railings. We know that Ms. Daines is wrong is because we learned today that fire and emergency exits are not required to have railings. Mr. Davis, if you put up Exhibit 6. This is a picture of the door leading to the loading dock. Look at the sign here. Do not block. Fire exit. Now let's look at the sign on the handle of the opposite door. Alarmed emergency exit. You heard today that emergency exits are not required to have railings. Not only are the doors to the loading dock labeled as emergency exits, we know there are only 2 ways into the store because it's in the middle of a strip mall. There's a front door and a back door. So of course the back door to the loading deck is an emergency exit. And because it is, railings were not required. Because the ordinary prudent store owner would not have railings on their loading dock, and because the applicable statutes do not require this loading dock to have a railing, the plaintiff has failed to prove negligence. Even if some of you believe the loading dock or concrete was unreasonably dangerous, plaintiff still failed to prove that Chimes failed to warn the plaintiff about the condition. Why? Because the plaintiff was on notice for 10 years. Notice for 10 years of the condition of that loading dock. The plaintiff admitted today that she was familiar with that loading dock, knew the dock did not have a railing, knew the stairs did not have a railing, knew that the stairs looked the same way on January 23rd of 2019 they had the whole time she was working there. And of course she knew all of that. She told us she took at least 1 smoke break a day and took the garbage out regularly. She said that she went out into that area about 20 times a week. Now, 20 times per week for 50 weeks a year, over 10 years. It's around 10,000 times the plaintiff has been on that loading deck. Plaintiff knew the condition of the loading dock. Chimes did not fail to warn her about it. Which brings me to the third thing the evidence has shown us today. It was the actions of the plaintiff and not Chimes which caused the plaintiff's injury. Plaintiff went out onto the platform for a smoke break. Even though the plaintiff has tried to say that she was forced onto the platform by Chimes, she was not. Smoke breaks are not required by an employer and not required by Chimes. Chimes did not want employees smoking in front of the store, but the plaintiff gone anywhere, out the front door and down the block away from the store, simply not taking a smoke break. But the plaintiff chose to go outside and chose to go down the stairs to smoke. The plaintiff had been down those stairs thousands of times with no problems. So what changed? Mr. Davis, if you'll pull up Exhibit 18 so we can talk about that concrete. While Mr. Davis figures that out, this time, Miss Huntsberger was holding the door open for the stairs. So instead of walking up the stairs next to the wall, as the plaintiff had done before so many times, plaintiff walked away from the wall, tried to go around the door. Plaintiff says this edge and corner, barely a foot width wide, is where she was walking when coming up those stairs, after moving away from the wall she was using before. She took this narrow path because Miss Huntsberger was standing in the door. But the plaintiff did not ask for Miss Huntsberger to move, to open the door all the way flush, to shut the door, to try to do either of those things herself. Instead, she tiptoed this narrow stretch to try to get up to the top. Now, if this skinny bit of chipped concrete is enough to be negligent, then my grandmother was negligent on her back stairs for every 4th of July, Thanksgiving, Christmas, Memorial Day, and Easter meal we ever had over there with 20 folks, from toddlers to grown folks, going up and down her stairs. No one asked Ms. Huntsberger to close the door, did not ask her to open it, but instead at 47 years old, plaintiff crept around the door, and when she felt unsteady, decided to jump, not forward, not to her right to the loading platform she was trying to get to, but decided to jump back off the loading dock onto the ground, even after making poor decisions to try and go around the door. Plaintiff still could have done a number of things rather than jump. She could have even held onto the door. Anything besides jumping back and onto the ground. And it was not until after the plaintiff jumped back to the ground that the plaintiff was injured. Plaintiff failed to use ordinary care. Plaintiff was negligent. It was the plaintiff's negligence that caused her injuries, not Chimes. Because the plaintiff has failed to meet their burden, because the evidence has shown that the loading dock outside of Chimes' department store was not unreasonably dangerous, because Chimes had no responsibility to put guardrails on the loading dock, no responsibility to warn the plaintiff about the condition of the loading dock she had been on thousands of times, and no responsibility for the plaintiff's actions while on a smoke break. You should find that Chimes' department store had no failure. You should find in favor of Chimes' department store. But even if you find that the back of Chimes' loading dock, that area marked with 2 signs saying emergency and fire exit, that meets the OSHA statutes, even if you do not find that the plaintiff was solely responsible for her own injuries after being up and down and around that loading area thousands of times, you have another option. Texas is a comparative negligence state. And when I was getting ready for today's trial, I was thinking of the best way to explain to y'all what comparative negligence means. So I thought about something happened when I was a kid. And when I was in high school, I played for our basketball team. One of our games, my senior year, was a late season game against one of our biggest rivals. And every year, the winner of the game got big bragging rights. So during this game, I got put in late in the 4th quarter. When the game was tight and we were on defense, Coach told me to get to the 3-point line as soon as we got off defense from the transition. I go in, the other team's point guard drives in, and I foul him. I foul him hard, shoots his free throws, makes the first and the second. One of the players goes to take the ball out, and I sprint to the other end. Ball gets tossed down the court, and my teammate grabs the ball. We yell to pass, and he shoots and misses. And after the game was over, we went back and forth about who lost the game. Was it because of my hard foul on that point guard, or was it because he missed the 3? And after we talked, we decided we were both probably at least a little bit to blame. And that is comparative negligence. So today you get to look at everything that happened on January 23rd of 2019 and decide whose fault this plaintiff's injury was. You've heard from the experts. You heard statutes. Heard that stairs were not required to have railings, that they weren't feasible, that it would have defeated the purpose. Those stairs on the fire escape were exempt from everything the plaintiff is trying to tell you was required. Their expert was trying to tell you was required. Chimes department store had no responsibility to put guardrails on the loading dock. No responsibility to warn the plaintiff about the condition of a loading dock she'd been on thousands of times. No responsibility to put rails on stairs for an emergency exit, and no responsibility for the plaintiff's actions while on a smoke break. Where there is no responsibility, there is no failure. Judge Powell is about to give you this verdict form. On this verdict form, you're going to ask if Chimes department store was negligent. Add up everything that happened here. When you do, consider everything you heard today. Now, I'm confident that you'll put no here. This form will also ask you if Jordan Gilmore was negligent. So add that up too. Look at the facts you know, that the plaintiff walked out to an area she knew was dark, walked to an area she had been thousands of times, and look at the fact that instead of moving the door out of her way, plaintiff at 47 tried to wiggle around and then jump backwards. That is when she was injured. That is negligence. And her own negligence was caused her injuries. For this question, check yes. Chimes Department Store is not responsible for the plaintiff's injury. Do not hold Chimes responsible. Find in favor of Chimes Department Store.
Rebuttal, Your Honor?
Yes, sorry. You may
Okay. And Your Honor, I'm not close to that 30 minutes, right?
No,
I didn't think so. May I proceed?
you may.
Members of the jury, defense counsel just told you they can't be responsible because the plaintiff, they were on notice. They walked up and down those stairs for 10 years. But you know who else was on notice for about 10 years? The defendant. After that report in 2010, where one of their employees said, hey, I think I just slipped on some concrete back there. I got hurt. After that report, after the defendant was on notice about that, did they do anything? No. See, today, defense counsel, they've talked a lot about responsibility. Who's responsible and who is not. And defense counsel, they've tried to say, it can't be us who's responsible. Instead, they tried to point the finger in every other direction. Pointing to fire exits, pointing to OSHA regulations, tried to pass the buck every which way they could. And it sounds a little bit about like something that the defendant's owner said today. Because remember when Ms. Geller was on the stand? She was being asked questions about repairing the concrete on those steps. And she said, well, that's the landlord. That's not us. She didn't want to take responsibility. But then she had to admit, she could have asked the landlord. She could have gotten it done herself. She could have picked up the phone and called the landlord and said, hey, we got a problem here. Could have written an email and said, guys, we really need to fix this. Heck, in the 9 years it took between that incident and 2019, she could have written a letter and put it in the mail and it would have arrived in time. She didn't do any of those things. She did nothing. She was the person responsible for that dock and for those steps. And because of that, Ms. Gilmore's injuries are the defendant's fault. We ask you find the defendant responsible. Thank you.
All right, thank you, counsel. Is there anything else from the parties before I excuse the jury to deliberate?
No, Your Honor.
Okay. And the case is submitted. I will ask the scoring judges to complete their ballots and email them to the tournament director. And when you have done so, please turn on your camera. We'll give some brief comments. And then when I have the word that we're good to go from the tournament, I will excuse everybody. So give us 1 second while we tabulate. Well, Mr. Dickens and I are law school classmates, and so I have just texted him that I'll hold him in contempt if he doesn't hurry it along. There he is.
Sorry, Judge, don't find me.
We'll consider your sentence. All right. Looks like we've got everybody back. A great round, everybody. Congratulations on getting through the prelims. I know this is a hard competition, and it is quite an accomplishment to get just survive the prelims. So congratulations and best of luck going here on out. I think we'd like to have the judges go around and introduce themselves and provide just 1 or 2 points of feedback for each of you. Y'all are really lucky to have some great trial lawyers that watched you today, and we thank them for their time. I certainly don't count myself among them. They are much better than me, and so that's why they're going to do the talking, and I'm going to sit back and listen too. But my name is Colin Powell, and I'm a 2014 grad from Baylor, a trial lawyer in Dallas, does primarily product liability and insurance defense on the defense side. So this is certainly within my field, this case, and it was fun to watch. So who wants to go first, Sam?
Sure. Great job, everybody. Both Mr. Nacino and Mr. Banks. My name's Sam Houston. I'm a trial lawyer in Houston, Texas. I graduated from Baylor in 1987. You guys really are starting to make me feel old out here. So I'll just give you a couple of points. And your style is your style. I know you guys have been doing this a long time, so I try to stay away from stylistic points on this, and you get a lot of suggestions from everybody. Really talk about, if you go forward, what I kind of thought you did or didn't do in this case, and maybe some things to think about if you're going tomorrow. I'll start with Mr. Nacino, since you were the plaintiff, and it was an interesting take from what you heard. I thought, you focused just on the step, on the concrete, and I'm sure that was an intentional, and you might have left some quivers or some arrows in the quiver. I heard other people talk a lot about the light, about the rails, and it was interesting that you focused on that. And at first I thought it might have been a mistake. And I still think maybe you left some out there, some more things to talk about, but maybe that's a strategy that you want to use and apply. But I think there was some more to talk about on the plaintiff side, and you kind of left it open on the contrib. And Mr. Banks, I guess what I would say from the defense side is y'all were kind of trying a different case. He was talking about the steps and you were talking about the rails. And I always think on the defense side, if the plaintiffs don't bring things up, and I do mostly defense work, you don't really need to address it again. So if you hear them doing that, then you have to switch your strategy. And I thought your strategy actually, I thought you did it very effectively of pointing out her own negligence. And then you picked up on the comparative negligence statute in Texas. I've always thought it would be interesting if on the defense side, because I think this case is a little skewed towards the plaintiff, the factual, that you maybe concede a little negligence and go for the contrib. It may be an interesting strategy that one of you may, if you're on the defense side, you may think about, because it is so hard to kind of talk when you just look at those friggin' steps, it just looks bad. The picture is worth 1,000 words, and you do see the gaping hole and all of that. And maybe when you're on the defense side, Mr. Banks, you would think about maybe conceding a little, but say she was certainly more than 90. She's the one that decided to walk around the door rather than, they're saying they should have fixed the steps. Well, all she had to do was open the dang door. And you kind of get into that argument, because I think from the defense side, that's your best bet. And great job, guys. Good luck. And I always ask this because I'm not judging tomorrow, Judge Powell. Where are you guys from?
We're allowed to say this, right, Judge Powell?
No, there's other people that might be judging more. Never mind. I've tried every way to violate the rules. Wherever you're from, whatever you do, good luck. I know you'll make great trial lawyers. It's a very satisfying business, and you'll learn a lot, and you're way ahead of where I was when I was your age. So good luck, guys.
Thank you.
Next on Mike's screen is Akila.
Hi, my name's Akila Craig. I am a 2012 graduate of Baylor Law School. And right as I turned it off mute, my dog started barking. So my apologies for that. I am a labor and employment attorney. I do sort of a lot of litigation, but also some counseling work. So don't know that I count as like a seasoned trial lawyer, but happy to be here. I think both of you did a really great job in terms of just really nitpicking, sort of just to clean up your approach. That's kind of where my comments come from. And so, Mr. Nacino, your cross-examination was going probably as perfectly as you could have scripted. And then you asked, and then what happened on the night of the 23rd? And that was the first moment where you left it for the owner of the store. She went along with it, but she could have said, regarding what? And that could have derailed the whole thing, because you didn't need to ask an open-ended question. You were lead the whole way down. And then from there, it sort of got a little shaky, because she was like, well, that's what the plaintiff said. That's what the plaintiff said. That's what the plaintiff said. So remember, and this is for both of you, but this is just a moment that happened right as we were watching it. This is the one opportunity you get to lead a witness all the way you want them to. Don't relinquish that when you don't have to. Keep it going, and that way you sort of set the tenor for where the testimony goes. But again, very nitpicky. I think, in fact, it continued to go well, because that's what the witness she had to own the fact that all of these were true statements. But just keep that in mind as you're asking questions as you go forward in the competition. Same comments that Sam made, Mr. Banks. You sort of were focusing on the guardrail a lot. And because plaintiff didn't really bring up the guardrail, a lot of the times I was kind of wondering, well, what am I supposed to do with this guardrail sort of information? And so the advice I would have, again, I'm targeting you, but I think this applies really for both of you as you're on either side of this case. The one thing, Top Gun, that makes it probably one of the harder competitions, but also I think it gives you a certain amount of flexibility, because you haven't been practicing, for months on the same problem, because you haven't had it. And so that allows you, I think, to be able to adapt to what the person on the other side, the argument that they're making. It allows you to sort of have that flexibility to say, okay, this is where I thought they were going to go with this evidence. They're going in this other way. Let me see how I can maybe pivot to better respond to the allegations. So if, for example, they're talking about the concrete being damaged, that's where, Mr. Banks, you say, the plaintiff had walked up and down those stairs for 10 years. She'd walked up and down those damaged stairs for 10 years. She'd opened that door for 10 years. She knew how narrow that width was. She'd, in the past, opened the door the full way. So she knew if she wanted to be safe on those stairs, she could have just opened the door the full way, whatever it is, right? Like, use whatever strategy you want to. The point is just being able to sort of be adapting to what the evidence is actually pointing to, So you're not just trying the case you want to, you're actually trying the case that's being presented to the jury. But again, great job, both of you. I think you both were wonderful. And so I'm excited to see where you go in this competition and your careers.
Great. Sammy?
Yeah, hey guys, I'm a commercial litigation attorney in Austin. I actually graduated from Baylor very recently, so I'm sure Colin is a much better trial lawyer than I am. But yeah, so I graduated in 2019, so I'm just a second year. But I was pretty heavily involved in mock trial, and so I kind of know what it's like to be in your shoes, and just really, really, really good job. I think both of y'all. A lot of people said this when I was competing, and I always thought like they're lying, but it's totally true what I'm about to say. I've seen so many lawyers who are way worse than the performance I just saw you guys do. And so like really, really great job. Y'all are already starting off on a great foot, and your future careers are going to be very fruitful. So excited to see what kind of lawyers you guys are going to be. But yeah, I mean, like Akila said, I'll just kind of make a general kind of global comment. I think it's very hard to do, especially in this competition with Top Gun, where you get the problem with not much time to prepare. But I think kind of the biggest thing that could apply to both of y'all is like and it's very hard to do, but I think you got to try the case in the room, right? And I think like when you're on a script and when you kind of have what you want to do rehearsed, it's really hard to kind of get off of that, but it's so important, and it means so much, and it's really effective to the jury and also the judge if you're able to adapt very quickly and able to kind of take what the other side's doing and work that in to your case, right? And so and Ryan, like you did do a little bit of this in your closing, and so I don't want to say like y'all didn't do this at all, but I do think it's just important to just be very aware of what the other side is doing and be able to be flexible and adapt that, because that kind of shows that you're on the next level, right? Because everyone has a really good script, and that's kind of expected, but the way you can adapt and kind of like really focus on what the other side is doing, that's kind of what's going to make a difference. But yeah, I'll just say very quickly, Ryan, yeah, I thought your cross was awesome. I'm a cross sucker. Like I love that. That's my favorite part of the trial. I thought the way you ended it was very, very powerful. And so that's kind of just like the main thing I had written down for you. John, I thought like this is just kind of, I don't know if this is a weird comment, but you just have this kind of like charm about you where like people want to listen, like when you talk, like and there were, some kind of like personal anecdotes you put in there that like some people might think that's, I don't know, a little out there, but I liked it. I really liked listening to you. I thought it was really convincing. I feel like a jury in the real world will really connect with you and like that. I think your redirect was really great, because it's so hard on redirect to not be leading or not be repetitive. And I think you kept it really short. It was awesome. The one thing I would say, and I think this might have been your second witness, but oh yeah, it was the deposition reading. I thought like when you were reading the actual deposition transcript, I thought you did a good job. I think when someone's just reading, it can be very like monotone, but I think you did good. But like there were a lot of parts where you just asked to constructively read it, I guess, and that's fine. I don't know what the rules are about that, but I do know like neither of you guys were really constrained as far as time. And so when you were saying that you would constructively read things, like I'm sitting here thinking like I have no idea what that is. And so I feel like if you're able to in the future, maybe just go ahead and read whatever you were going to do constructively, because for me that was just kind of left like in the air. Like I didn't really know what was going on. And so that's a very minor thing. And I'm not saying that's like that went against you or anything, but I think that's just something to keep in mind. But yeah, overall, really great job to both of you guys.
All right, Brad.
Thanks, Colin. Like Colin said, my name is Brad Dickens. I graduated from Baylor in 2014. I do primarily commercial and insurance defense litigation here at a firm in Dallas. And so, I just want to say, just first thing, I know obviously you guys especially, John and Ryan, you're coming up in law school in kind of an unprecedented time. And so this may all be, second nature to you, but great use of tech. I know we're not judging on tech, but you know, as someone who actually tried a case by Zoom last fall, I know what you're going through. It's not easy. Little things like, John, I noticed when you were kind of near the end of your case, you had your co-counsel try to pull up a document, and I could tell that it wasn't initially coming up, or it wasn't coming up as fast as you wanted. And you did a great job of just rolling with the punches and just saying, well, he's finding that. And you just, you know, you didn't let anything phase you. Ryan, you did a great job as well with that. Just, you know, having the, you know, the way that you highlighted the, you know, the area around the steps, and just, you know, I thought it was a great use of tech. Again, I know that's not the main focus of this, but it's part of trial these days. And so I think great job overall. I agree with Akila. My general sense on cross is don't ask questions you don't already know the answer to. And in fact, I would say generally, and again, this is maybe a personal style thing, but I generally don't even ask questions at all with an adverse witness. I just tell them how it is and just say either true or correct. And just, you know, you want a witness to get off the stand having just agreed with almost everything you've just said. Like she said, this is your chance to lead the witness and basically control the narrative, as opposed to giving them the keys and letting them kind of take it a different direction. I agree with Sammy. John, I really liked your some of the personal stories. I liked the one about, you said it better than I could paraphrase it, but you know, about your grandmother coming up the stairs in the back of the house. I thought that was great. I could really see a Texas jury, you know, relating to that. I also liked your analogy for contributory negligence with basketball. I would say maybe it's a good analogy. I would say maybe shorten it a little bit, but I think the point got across, and I thought it was a good use of just, you know, showing them that, look, you're a real person and you've got stories, and just like the jury, you know, is going to bring in their own experiences. So I thought that was really good. I know everybody so far has talked about, you know, trying the case that is in front of you. So I do think there's, it did seem a little confusing sometimes when it seemed like there were two different cases going on, one about the step, and then one about whether it was a loading dock and OSHA regulations. I think you know, I think something that could have really been hammered home, especially Ryan, and you did it a little bit, but you know, the defense tried to make this argument of, well, she could have smoked wherever, right? She could have walked down the street, but you've got this memo where, you know, where literally the owner of the store is saying, you know, okay, no, you have to basically saying you have to smoke back out in the back. You know, we don't want, it sort of comes across almost like we don't want your kind out in the front of the store kind of thing. It's just not a good look. People don't like big corporations anyway. And so when you've got somebody telling a working class person, hey, take that, you know, we don't want you out in the front of the store, be in the back. You know, I think that's something you could have really hammered management on a little bit. Like, you know, no, they couldn't have gone down the street. You told them that they, you know, they're on short breaks. They've got 5 minutes to do this. You know, you should have been, I just think that's something you could have really hammered them on. But overall, like everyone said, great job. You guys did a really great job as far as just, you know, telling your story to the jury. You did a great job with the witnesses and the evidence. Good objections on both sides and good responses. That's always a hard thing, because you never really know what opposing counsel is going to jump up and object to. And so great job on that. Great use of and just knowledge of the law on that. And so good job to both of you, and best of luck to both of you going forward.
All right. Well, thanks everybody. Thanks to the judges for their time today. Competitors, congratulations. Good luck as you go on from the prelims.
Thank
you. Y'all, we're good from the tab room, so we're free to adjourn.
Thank you all very much.
Thank you. Good luck.
Awesome. Good luck, guys.